I stuck there, then may not reach, my lord. Therefore, if taken up, my lord, after 12 before this court, then I will come, my lord.
And, may I say one thing? May I resolve this? 11:30, my lord has a fixed matter. 12:30, there is a fixed matter. And after this half, my lord, my lord will take up company matter. My lord, if not taken up by 11:30, it will come and mention before the lordship at 11:30 and get it fixed on another. Let us give my lord time.
Okay.
I think.
Next.
My lord, may I have my lord's leave to mention a matter? My lord, it's a company matter, my lord. My lord,
Who is senior?
Your Lordship, upon notice to the other side, I'm mentioning this matter, Your Lordship. Your Lordship, this is regarding Your Lordship filing the affidavit of competency and the Wakalatnama along with the judge's brief and all these things, Your Lordship. The time was given, Your Lordship, till 6th of August, Your Lordship. What happened, Your Lordship? We had filed the Wakalatnama pursuant to the direction of the department, Your Lordship. We had filed a fresh Wakalatnama, Your Lordship. And that was on June 19th, Your Lordship. And the documents that were affirmed, Your Lordship, along with the affidavit of competency and the Wakalatnama was in January 2025, Your Lordship. And that copy was served to the other side also, Your Lordship, pursuant to which they have filed the written statement. Now the department is saying that since that was affirmed by a person whose affidavit of competency
Was
is
not
not
there.
there, Your Lordship, they cannot take it. But Your Lordship, we have the affidavit of competency when this was affirmed, Your
So
Lordship.
when the
That's
matter
it.
is fixed,
Your Lordship, September 22nd, Your Lordship. September, Your Lordship.
so let that application is to be not pressed first. Then you have to file this.
Your Lordship, there is no application, Your
So what-
Lordship.
what-
This is regarding, Your Lordship, the statement of through the amended charges.
Earlier who filed the restatement of truth?
Your Lordship, earlier we had affirmed, Your Lordship,
Ah,
and leave was given, Your Lordship.
ah.
They wanted a fresh Wakalatnama.
What
Since,
you have served to the other side?
Your Lordship, the one that we have affirmed, Your Lordship,
Okay.
in January, Your Lordship.
But
that we have served.
that is not filed.
That is not filed, but we have served. And
Without
pursuant
filing
to that-
you have served the copy.
Yes, Your Lordship.
Okay.
Pursuant to that, they have filed their
So you
written
write a
statement.
letter to the other side. Write a letter to the other side. Inform the other side, giving the circumstances, and you serve the new one, and it will be accepted by the department. No problem.
Then we have to withdraw this, but Your Lordship.
Because you are not filing the court. That
we
earlier
have not, Your
not
Lordship.
file the
No,
court.
no,
So
Your
question of withdrawal does not arise. Only you write to the other side, which you are not harping upon that. You are not relying upon that.
They have
statement.
filed the written statement.
Okay,
and-
whatever it may be, then you file the new one.
We have filed the written statement basis. This
And Your Lordship, inspection was
inspection has been
completed.
completed for that.
Okay, let the matter come in list. Let the matter come on the list. Tuesday has to be mentioned. Come both the party. I will see the record. What is there?
Yes, Your Lordship. Deeply obliged, Your Lordship.
Circumstances, my lord, I wanted to, my lord, move 2 applications without search.
They want the cost title.
Now, my lord, it's a, my lord, the writ of summons has not yet been issued. Now, my lord, the department is of
When the presentation of plaint was heard.
presentation of plaint, my lord, head, my lord, last month.
Hmm.
Now, my lord, writ of summons could not be issued, my lord. Now, my lord, I wanted to, my lord, there are some errors which has taken place. I have filed an application. Now, my lord, the department is, my lord, insisting that this has to be served. Because, my lord,
Application for
application for, my lord, correction of, my lord, in some, my lord, in the plaint, then, my lord, I will serve
amendment.
amendment. Then I will serve the corrected plaint.
Hmm.
Now, the department is saying that it has to be served, otherwise it cannot, the master is not signed.
Hmm.
Now, I made it, I requested them because the writ of summons has not been served. This can be done prior to that.
Hmm.
So, they are of the view that if my lord gives leave, they can sign the if endorsement is being done on the back sheet of the application, they can allow. This is the only thing.
What is the application?
Amendment.
Where is the application?
This is here, there are the 2 applications.
It is affirmed.
It is affirmed everything. It is lying with the master. I have taken leave from
So
them.
what you want now?
A leave from your lordship so that it can be filed and it can be moved before your lordship. Because writ of summons has not been filed, served. I have also prayed for a leave for extension of time for writ of summons.
So this is on with regard to the amendment in the plaint.
Amendment. And we'll add one other application.
Okay, leave is
the
granted to
extension of
file
time.
and place it. Leave is granted in place before this.
2 applications.
My lord, may I be permitted to mention a matter upon notice, my lord? Once it's a company matter, my lord. My lord, this matter, my lord, had directed for personal appearance of one of the joint special officer, my lord, on 3rd September 2025. Well, there are some personal difficulties.
Come at 2 p.m. mention. Company matter will be taken at 2 p.m.
May I take your kind indulgence to mention one matter which was fixed on 7th of August 2025 as a fixed matter for the witness action at 3 p.m. As your lordship was not there, so the matter is now running in the list in the lower portion.
Hmm.
So please,
What is the witness action?
witness
Which
action
on the other
expert,
side?
expertly witness action is a order
Defendant
37. Yes,
Thompson matter.
kindly your lordship fix one
Which
date.
serial number?
Lordship,
Which serial number?
today it is running item number 174.
170?
One. Oh,
174. Witness action.
witness action. Take on Infrastructure Private Limited versus RTT Enterprises.
Though the matter is listed as serial numbers 174 in the today's list, but the learned counsel for the petition plaintiff has mentioned the matter and informed this court the matter was fixed on 7th of August 2025 for witness action at what time?
At 3 p.m. it was
At
fixed.
3 p.m. But due to non-availability of this court, the witness action could not be taken place, and accordingly it pays for fixing another date and time so that the witness can examine the witness. Plaintiff can examine the witness. In view of the submission made by the counsel for the plaintiff, let the matter appear on. No, it is a lengthy witness.
Only one witness is there and several documents.
Several documents, then
Yes.
time lagega. September when?
Lordship, prior vacation, is it possible?
That's why if it is shorter than it private vacation 345. Otherwise, nahi hai. At 25th September at 3 p.m. for witness action.
Wait for Lordship.
Yes.
But I need to make and undefended manner obtain a copy or obtain a certificate manner as far as yet we have not received any.
When the writ of summons was served?
Someone was served on December 2024 manner.
And they have not entered appearance.
Filed an application for extension of leave to file and written statement. The same was dismissed for default on March 2025 manner. After that, they don't have served anything or they don't have filed any application.
What you mentioned, Mero?
My lord, may I be permitted to mention item number 11 of today's list, my lord. My lord, both parties have entered into a settlement, my lord, and we would like to file the terms of settlement before the court.
When you will file?
Right now, my lord.
Today?
Today. My lord, there is
The
all.
other side?
My lord, he is for the
Yes.
other side.
Yes. What is the suit for?
Suit for recovery of money, my lord. And they have entered into on
What was
last
the
of
total amount?
13 lakhs
13 lakhs.
12 lakhs something was the principal amount.
and the interest. They have agreed upon
Already
paying.
agreed upon on 13 lakhs.
On
13 lakhs.
lakhs.
6 lakhs, 50,000
They
already.
have already paid, my lord.
And what about the other amount?
Other amount they will pay within 3 months, my lord, as for the agreed terms. And my lord, one more thing, my lord, on last occasion, there was an injunction order they are suffering from. If this is agreed upon, that injunction order may be vacated. Item 11, my lord.
Item number 11. Counsel for the parties have filed terms of settlement entered between the parties on. What is the date of the terms of settlement?
My lord, today. Maybe.
But it is not affirmed. Where is the affirmation?
My lord, they have affirmed it.
Either affirm or notary public.
I'll just do the note.
Come tomorrow.
My lord,
Monday?
tomorrow I have certain difficulty,
Monday?
my lord. Can it be on Monday, my lord?
Monday. To be mentioned.
Lordship, may I be permitted to mention item 46 of your Lordship's commercial list? Lordship, I have an application GA1 for acceptance of written statement. Lordship, the time to file my written statement expires on 19th of August. Your Lordship, my only humble prayer that it may be taken up.
Item number?
46 of your Lordship's commercial list.
When you receive the writ of summons?
Lordship, 19th of April. My time expires on 19th of August. So, Lordship, may kindly take it up any day convenient to your Lordship before 19th of August for acceptance of the written statement.
Where is the written statement?
Lordship, I have already filed it with the department.
It is filed, no problem. So, what do you want?
No, Lordship, out of abundant caution, your Lordship, because the time was expiring on 19th, your Lordship's practice is generally to mention it before the time expires. So, your Lordship, I was mentioning it if your Lordship kindly gives it.
GA.
Yes, your lordship. GA1.
GA से new motion में रख दो.
Any day convenient, your lordship. Grateful, lordship.
Yes, next.
May I, my lords, kindly leave to mention a matter, please. May I, my lords, kindly leave to mention a matter.
Yes, Mr. Thakkar.
My lord, this matter here was taken up yesterday where your lordship had directed us to serve a copy of the plaint. That section 8 application, your lordship remembers, my lord.
That yesterday, my lord, was your.
Yes.
So, my lord, we've served
have a
the
response number
copy of the
one.
plaint. Yes, my lord, we've served the copy of the plaint, my lord.
Yes.
Your lordship was pleased to keep the matter on 25th. I was
Yes.
humbly praying, my lord, if it could be any time next week, any date, my lord, convenient to your lordship. Because, my lord, my GA1, which is the interlocutory application, my lord, that is not being heard because of all these dilatory tactics of theirs.
The manager was there and it was fixed at his.
Okay, I am fixing. Let Mr. Thakkar complete if I time permit. कब time है? Next week में कुछ time.
The date has already been fixed on 20th and we are supposed to open our substance.
I am telling Mr. Thakkar will argue. I will not pass the judgment on the same day.
Our application, your lordship, section 8.
Okay, let the matter fix on Monday as a specially fixed matter.
Grateful,
You
Lord.
are not understanding what the court is telling. Mr. Thakkar is the petition. Let he argue the matter. I am not telling I will not give the chance to you. No, early morning you are not understanding what the court is telling. You will not come any day for.
I am telling section 8 application is there as GA2. That has to be heard first.
The court will decide whether rate will be decided first or whether the injunction will be decided first. Next week considerable. 19th August. 19th August. Record an order. Though the matter is fixed on 25th of August 2025, but the learned counsel for the plaintiff submit that the plaintiff has filed an application for interim order and there is an urgency. In view of the submission made by the counsel for the plaintiff, let the matter appear on 19th of August as under the heading new motion at the top.
Grateful, my lord. Deeply obliged, my lord. Grateful.
To mention a matter, my lord, this is that Gunwant Rai, that Ojha matter. The lordship has been pleased to pass and has been pleased to condone our, my lord, latches. My lord, the order we have perused, there are one or two, I believe, my lord, typographical errors. If your lordship kindly, my lord, keeps it to be mentioned one day, my lord, corrects it.
My lord, I appear for the respondent, your lordship.
Yes.
Like, my lord, in paragraph 27, your lordship, the earlier paragraph your lordship has recorded, defendant number 2, in the present suit, the father of the petitioner number 2 was the defendant number 2 and the mother of the petitioner number 1 was the defendant number 4. But after that, now your lordship has corrected it and said in the present suit, the father of the petitioner number 2 was the defendant number 2. That's fine. And the father of the petitioner number 1 was the defendant number 4. My lord, that may not be correct because Chimanlal was never, my lord, a party even. Different number 4 was 1 or 2, my lord, just clerical, my lord. And my lord, possibly it was the last day was today to carry out. My lord, even the department, my lord, we have gone number of times because of some 2 or 3 difficulties they also have. They would also seek some extension of a week's time.
Yes, next.
Any day.
Sure.
Yes.
Chimanlal Ojha was made a party in this suit, my lord. His son Anup Ojha, my lord, substituted him.
Okay.
And your lordship has kept that substitution.
Okay. Come on that day, we'll see.
Yes.
नहीं नॉन कमर्शियल 2 बजे ना. अच्छा आज नहीं, हाँ दे दो.
I'm for the petitioner, your lordship.
This is non-commercial list, sir. I'm for the
Non-commercial list. I allowed that deletion of the 1 and 2, and with regard to this gazette notice, I directed you to publish the gazette.
For the gazette, I had used that note.
Yes, your note. I have decided that it is required. If you agree, then you take it.
Kindly, no, not that. But I had relied on Rule 41.
I have gone through. I have decided all this.
Very good.
I have decided all this.
Well, the election commission indeed has been.
He's not a party, but he has no right anymore now.
Your name has been deleted.
That is what I'm grateful.
Grateful, madam.
Both names have been deleted, and the petition is directed to carry out the gazette notice.
I'll do that. Grateful to you.
Grateful, madam.
2 weeks time is granted to you. 2 weeks time is granted, and
Instead of 2 weeks, my lord, may I pray for a little more time, my lord? May it be, my lord, done
but
with
election petition, that's why I kept.
very good. But 3 weeks, my lord,
Okay,
1 week
3
more, but great.
My lord, I am for the plaintiff.
In this case, I have concluded that the judgment is not applicable in the present case. You have to pay the stamp duty. Yes.
My lord, I am appearing for the
I'm for the petitioner, Your Lordship.
Yes, GA.com is allowed. The defendant is directed to pay the amount along with the interest of 12% per annum.
deeply obliged.
I'm deeply obliged.
Very
good.
CS is also disposed of.
I'm deeply obliged.
Deeply obliged.
My lord, I'm appearing for the plaintiff respondent.
Yes.
And my written notes, my lord, I am seeking leave. Rather, it is already ordered. I'm filing.
I also file my written notes for the petitioner defendant to also revocation of clause 12 application.
Both the parties have filed their written notes of argument. Let the same be cut with the record. CAV.
Grateful.
Thank you.
My lord, item number 3, the matter has come at the behest of the plaintiff, my lord. My lord, the cross examination in chief was going on, and my lord, the date was fixed. It was continuing. The date was fixed, my lord. On that day, my lord, the court function was not there, my lord. So, my lord, the matter was mentioned, my lord, and please to keep the matter as to be mentioned, mainly for the fixation of a date for the continuation of the examination and conclusion of the examination in chief. So, my lord, I'm leaving it to your lordship on is a small, very few documents are need to be gone into and make question of. So, my lord, may it be in the month of September, my lord, subject to lordship's convenience, my lord.
Lord, may I only indicate, my lord, I am appearing, my lord, for the defendant. May I be permitted to today, my lord, be online? I have filed an application under Order 7, Rule 11, which is
My lord,
GA
these
number
issue
which
was
has not been served.
decided long back, and despite that, my lord proceeded with the examination in chief.
No.
Every day, if they think that the matter will come,
No.
and they will refresh the issue
I
once
don't
again
think it's
with
not
an
letting me
attempt.
make submissions. Okay,
application
defer
not
an application without that application. Let me, my lord, impugn the plaint right here, right itself. My lord, your lordship will
My
see,
lord,
my lord, this is a dispute. This is a commercial
it has
dispute.
already, my
My lord, that has commercial
already
dispute that has
heard
been
it.
filed.
What is
No,
this?
my lord, this has not
It
been
is for the
argued.
fixation of the date for examination in
This
chief.
has not
My
been
lord has
argued by
recorded in
me.
my lord's
I
last
don't know
order
why I am
also.
not being able to, my lord.
About this,
This
they
is a
have closed. They have
courtesy.
got their chance to file WS closed.
My lord, today the
You do one thing, both of you dictate my staff what order is to be passed, then I will sign that order. If both
no,
are
I
arguing
leave it to your
together,
lordship.
then you dictate the
I leave it to
I
your
have
lordship.
already left to your lordship, my lord.
If
I
you
was only
starting arguing the matter from themselves,
no, I was only asking for an opportunity, my lord, to submit before your lordship for 30 seconds, not more.
for what? For what?
This, my lord, the point of jurisdiction, whether it's a commercial dispute or not, has not been taken. I filed an Order 7, Rule 11, my lord, which is GA3, not served. I will serve it, my lord, in course of the day or by tomorrow. Now, this is a simple suit for money lent and advance.
Okay, Mr. Sengupta, you whatever your application you filed, you serve the copy, let the application come for hearing. But at this stage, the case is at the stage of evidence. I am fixing a date for examination. In
Yes.
the meantime, your application will come or whatever.
Yes. That is the only
problem. You
thing
file your
I was not standing in the way.
Because neither court
It's filed, ma'am.
nor the plaintiff will restrain you to file an application. If the application come on board, the court will decide its own merit.
I am so grateful, my lord. Yes. Your lordship will kindly do that. Yes.
The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. Counsel for the plaintiff submit that the matter is at the stage of examination of the plaintiff witness, and he prays for fixing a date for examination of the plaintiff witness. Counsel for the defendant submit that the defendant intend to take out an application for rejection of the plaint or return of the plaint as the suit is not
Already filed.
Already filed. Counsel for the defendant submit the defendant already filed an application that the suit is not, this court is not having jurisdiction and the suit is not of the commercial in nature. This court find that the application filed by the defendant is not in vote. As per the order in CS number 172 of 2023 and now CS Com 540 of 2024, the case is at the stage of evidence. Let the matter appear. Give the date.
Any date within the second week of September, subject to Lordship's permission.
Second September. बाद में देखो कोई डेट है 11 September at 3 p.m. witness action.
As your Lordship, please, my lord.
Yes, next.
Both are great.
Yesterday, my lord, while Mr. Singh was mentioning this matter, my lord, I had said that there may not be any witness who can come up and depose regarding the events that had happened in 2001. The suit is of 2004, my lord. The incidences are of 2001 too. My lord, your lordship had given me an opportunity to take instructions, my lord. Now your lordship sees it's a bank, my lord. My lord, my advocate record is here, my lord. My lord, he told me that no written instructions has yet come. We have advised them. He's seeking, my lord, if your lordship takes it up next Wednesday or next Thursday, my lord, by that time we'll have the written instructions and then, my lord, we can proceed with the suit. Otherwise, we'll be wasting your lordship's judicial time, my lord.
So your witness action.
My witness action.
The
I was
defendant in
this suit.
You will confirm whether you will adduce the
Yes,
evidence
Lord.
or not.
Just a written instruction that.
So when it is to be fixed?
Kindly keeps it next Wednesday or next Thursday, my lord. Any day, my lord. By that time, my.
I am fixing on 21st. Has to be mentioned.
Yes, my lord. I'm deeply obliged.
As per prayer made by the counsel for the defendant, let the matter appear on 21st of August 2025 to ascertain whether the defendant will adduce any evidence or not.
Lord, money claim on account of Lord defalcation or a subsidized amount of Lord government scheme from the government scheme. Lord, leave Lord under clause 12, Lord, but unfortunately, Lord, there's some mistakes in the plaint. I must, Lord, indicate to your lordship.
What is the mistake?
First mistake, Lord, is Lord kindly takes a paragraph 2 of the plaint. Lord, your lordship would find, Lord, Lord, the official address of the company, defendant company, has been correctly stated. But Lord, the jute mill that is operating, Lord, that has to be Howrah Chengel. Lord, because of Lord hasty filing, Lord.
Yes, paragraph 2.
Paragraph 2, your lordship would find, Lord, the registered office of the defendant company, that is correct. With respect to the address of the jute mill, that will be, Lord, Howrah Chengel, which is outside jurisdiction.
Not 16 Bourbon Road. So you want to correct this?
Lord, that is to be corrected. And, Lord, the other correction is with respect to, kindly comes to page number 9, para 26.
Yes.
The last sentence, the act will be deleted.
Para 26.
Para 26, the last sentence of para 26, act will be deleted.
Yes.
Lord,
yes.
And page 10 also, in the prayer, my lord, the same thing.
Okay. So yeah, today I am giving leave to amend, correct this.
Yes,
and
Lord,
after correction it will become.
Further corrections. Lord, paragraph number 18 and 19. After the amount, your lordship would find, my lord, a comment is there that has to be struck off.
What?
After, my lord, the amount.
Add into subject.
That amount, my lord.
So you have given the draft to your, then that has been typed as it is.
Kindly, my lord, grants me that leave, my lord, so that I can.
So these are the corrections.
Yes, these are the corrections.
Though the matter is listed under the heading presentation of plaint, but the learned counsel for the plaintiff submit that there are some corrections in the plaint and press for leave to correct in the plaint. Counsel for the plaintiff submit that in paragraph 2, the address of the jute mill is to be corrected as
Lord, it will be, Lord, Chakashi, Chakashi,
Chakashi,
comma, Pio Chengil, Chengail,
Chingil,
comma, Howrah 711308,
instead of
which is outside jurisdiction.
instead of 16 capital A, Barabon Road, 7th floor, Kolkata 70001. 00001. In paragraph 18, the word mentioned in the bracket added interest up to date is to be deleted. Comma in paragraph 26 and in prayer portion is mentioned in latest patent. The act is to be deleted. In view of the submission made by the counsel for the plaintiff is granted leave to correct the address of the equipment in paragraph 2. In paragraph 2, comma delete the word up to the date. Delete the word added interest up to date at paragraph 18, and to delete the word act in paragraph 26 and in the prayer portion. In course of the day, during the course of the day, after the correction, let the matter be placed before this court for presentation of Plaint.
Lord, your lordship has only seen me argue. Mr. Chatterjee, my lord, was leading.
Record the name of Mr. Chatterjee. Yes, next. Mr. Banerjee, that matter, 26, one matter, yesterday I fixed the 26. One Mr. Thakkar had appeared. Na?
Yes.
So I had
Well, that's section 8 matter.
that is postponed prepone on 19. He wanted to argue the matter in injunction application, interim order.
But Malad, section 8 will have to be heard.
So let Mr. Thakkar argue that matter on that day, and I will take your application on 26.
But Malad, section 8 has to be heard
both
first.
Will be taken up together. Both will be taken up together. Because he is harping upon the injunction. Let
But
the both
19 Malad at what?
So you will not be there. Your junior will be there. Then I will fix for your chance.
Very well.
I will not decide the matter. That's why your junior told to the junior.
I won't be there in the morning, Malad.
No problem. That's why I know, because on the junior.
Yes.
The junior was telling, but he's not understanding that. So he's
Malad, I thought section 8, Malad, I'll have to move first. That's the only reason.
He wanted to move. Let both the application I will decide. No problem. On that day you
or 18th or 20th, Malad, if any other date is possible, then Malad, I can Malad also.
But my diary would not permit.
Oh.
So I will take your both application. I will take and I will decide whether it is here or there, whatever it may be. Yes, Mr.
Milord, on the last occasion, Milord, I was placing some of the facts.
Yes.
I had placed the agreement, Milord, to show that what was the actual intention. I have drawn your lordship's attention to the power of attorney. And Milord, thereafter, Milord, I was trying to impress upon the court that at a given point of time, because this development was to take place from 2019 within 36 months. That had not happened. And your lordship can take a note, the completion certificate had ultimately come in April 2025. Now, Milord, as the parties, Milord, were progressing with this, Milord, and we were continuously trying to get the property, Milord, developed for the purpose of, it came across, Milord, and I placed this letter that it came across that somebody, a point had come, Milord, where we were looking for selling of this entire allotment,
Property.
both, and we had brought in, Milord, a third party who had actually entered into a memorandum. There, Milord, the price was fixed, but ultimately he backed out saying that no, and on due diligence, I have come to know that Merlin has already created a mortgage and I don't want to deal with it. Thereafter, when I confront Merlin, Merlin says, yes, I have mortgaged the property because the title deeds were with me. And he admits that I have taken the loan for some other project, which, Milord, the development agreement did not. So at that junction, Milord, I had stopped. Now, thereafter, Milord, your lordship will find
if your lordship, my lord, kindly comes straight to, my lord, page 255.
Two 55.
Page 255.
Yes.
My lord, this is, my lord, I'm showing this not for the purpose of any other reason, only to show that in January 2024, my lord, the Merlin has given us a timeline as to when he will complete. Your lordship will find a chart something like this too. Kindly make a note of the last entry. Application for completion certificate we were expecting on 15th of June 2024. This is of course subject to 4 and 11. But my lord, I take it that the promise was that by 15th of June 2024, the property would be complete and we can, my lord, proceed to market and our units in terms of the development. Now, all of a sudden, my lord, we come to know, then, my lord, I kindly come straight to the impugned order. All of a sudden, my lord, we come to know at page 307. There are minor issues here and there. I am not addressing your lordship because I am at an ad interim stage. It could come after affidavits. My lord, this is for the first time, my lord, we come to know from Mr. Vishal Jain of Merlin Projects addressed to Ravindra Kumar, Managing Director, Statesman. We are pleased to inform you that in terms of the development agreement dated 26th March 2019, together with the power of attorney and pursuant to the minutes of the meeting of 10th of May 2024, we have sold, transferred and have given khas possession to the purchaser of Fort Chorongi in its entirety. Save and except 1500 square feet reserve price for your office on the 3rd floor. We have also received the sale consideration against the said sale. You are requested to meet me earliest for further steps and to close the matter. This is, my lord, where the breach takes place and this is, my lord, where my cause of action arises.
Yes.
So he says that I have,
Yes.
my lord, I can understand, my lord, a person having authority to sell said that I have sold the property. My lord, your lordship will find there is an indication, my lord, in this letter itself to explain that how I have got the power to sell. Generally, my lord, so my lord, this author of this letter was aware that he had to explain. So he says that I have used the development agreement, the power of attorney and the minutes for the purpose of selling. So I immediately write to him. Then he writes to me saying, Vishal Jain on 7th of July kindly turns over the page at page 225. We are supposed to meet today in person.
Page?
Next page, Miller, page 308.
Yes.
To close pending issues, including the accounts of the sale portals pertaining to the aforesaid property. However, we understand that the proposed meeting has been cancelled from your end, as intimated by Mr. Sach and Sach yourself over the phone yesterday. In the circumstances, we are attaching here with a scan copy of the sale deed, the statement of account as marked annexure A1 of the sale proceeds of your share, along with adjustments of amount receivable by us on accounts of loans, advances, interest, various payments made by us on your behalf from time to time on different heads. Let us know whether your further payment is required to be made on your behalf. Please let us know. So, my lord, he proceeds on the basis property is sold. I am holding the money and I have adjusted it on my own. And I am giving you this at page 309. When, my lord, I only get he done all the adjustments on his own. And this is what I get according to him. Now, he annexes the sale deed.
Yes.
Which is, my lord, very important.
Yes.
Your lordship comes to page 310.
Yes.
Your lordship will find this is the conveyance of 27th of June 2025. At the bottom of the page, your lordship will find under section 32 adjudication case number 1 of 2025.
Where?
At first page 310
Uh,
at the bottom,
certified that the full stamp. Ach.
just above that.
Under section 32 adjudication case 1 of.
So, Millard, what is this adjudication case, Millard? If your lordship law, Millard, kindly comes to page 342. We all come to know of this in July. So this is the order of the Government Office of the Collector 11 and so and so. Whereas an application along with an indenture of conveyance was received by this office on 26th of March 2025. So, Millard, in 2025 March, Millard, this thing was going on. We did not know anything of it. They prepared this deed of conveyance and presented it from Merlin Projects Limited, constituted attorney of Statesman Limited. And whereas through letter they have requested for assessment of stamp duty, heritage grade 2 property premises number 4 as per the provisions of the India Stamp Act. And whereas a copy of the revised indenture of the conveyance between Statesman, Merlin and Hatishala was received by this office on 23rd of June 2025, stating the total considered an amount for the said conveyance is 2 crore 35, and whereas in accordance with this schedule, the proper stamp duty would be 7% of such and such, which is 16 lakh or 45 lakh, such and such. So, we come to know for the first time that Merlin had previously also behind my back attempted to Millard present and get this deed registered.
Yes.
We don't know who the buyer is, which did not materialize. And thereafter, Millard, they have found this purchaser who is Millard, the defendant number 2, and has done it. This would be relevant because I'll show just 3 days prior to that, Millard, we had entered into a lease jointly with a third party. Just 3 days prior to 26th of March. Millard, your lordship is 26th of March 2025.
Yes.
Now, Millard, your lordship will kindly come straight to page 257. Kindly keep these side by side, Millard. Oh, it cannot be. It's in the same page.
Page.
257. It can't be side by side.
Yes.
Millard, kindly mark. I had shown 26 March 2025. Kindly see, Millard, lease deed of 6th of March 2025.
Yes.
Between Statesman, the lesson number 1.
Yes.
59 Merlin, lesson number 2.
Lesson
And
number
Plaint
1.
Limited.
Lesson number 1 is
Statesman. At that page 257, the Statesman. Third line from the bottom is
the
lesson
Statesman.
number 1.
Correct.
259, your lordship turns over. Merlin Projects Limited, lesson number 2.
Yes.
And the lessee is Trent, such and such, Indian car having its office at such and such, and HLBL is the second part. It's the lessee.
Yes.
Now, kindly see the recitals of the grant of lease. Well, kindly come to 260. 260.
Yes.
The lessors hereby grants lease for the first time in respect of the leased premises unto the lessee for operating, carrying on inter alia its business and for any other purpose as lessee may deem fit, for a term as stated in part 7 of annexure 3. Part 7 of annexure 3, Millard, your lordship can make a note of it, is at page 287. Or my lord, if your lordship starts from 286, your lordship will get all the particulars of this.
Annex 3, yes.
My lord, your lordship will find building details, statesman, business, building or ready-made garments. This is my lord west side. Lease premises, my lord, the various commercial portions of the commercial areas in given
Yes.
type. And my lord, the lease was, my lord, for 288 months. And the breakup and enhancement of lease rent is given at page 287. Yes.
Yes.
So, my lord, this was the lease. My lord, there is a concept of revenue sharing at the bottom.
Yes.
Now, my lord, kindly come straight to A at page 259. I'm sorry, my lord,
So
because
the deed is with whom?
this lease,
Deed of conveyance?
my lord,
Deed of
deed of
conveyance?
conveyance is with my learned friend. The reason I'm showing this is the deed of conveyance with the defendant number 2. The reason I'm showing this is that as late as on 6th of March 2025, the defendant number 1, Merlin, acknowledges that the development agreement and the power of attorney is the only operating agreement between the parties. Will kindly see page 259A. The lesson number 1 is the owner of non-agricultural plot of land, more fully described in part 1 together with grade 2 heritage building. The lesson number 1 for commercial exploitation of the building has entered into an agreement of 26 combined by registered officer so and so. With lesson number 2 for undertaking necessary addition, alteration, renovation, upgrading infrastructure facilities, including construction of new block wherever necessary thereon, and has also granted power of attorney for a duly registered such and such for undertaking the aforesaid work, including sale of the constructed area and a leasing of the said premises. The lesson number 1 for availing financial assistance the registered mortgage such and such has mortgaged the said premises. The lesson number 2, based on the development as per the plan of the has upon investment of substantial or completed additional alteration of the existing building. And in Milord, it goes on, which acknowledges the fact because the reason is, Milord, in the deed of conveyance, they don't acknowledge this. That's the reason, Milord, I was trying.
After this lease, whether the tenant is taken possession of this?
Yes, Milord, he's paid rent. And Milord, not only this, Milord, your lordship will find lease rent 3.1 at page 260.
Yes.
Kindly turn over the page. In consideration of the lease in respect of the lease premises, page 261, granted by the lessor unto the lessee under this deed and subject to the lessee having access to the right to use or occupy the lease premises for the purpose of obtaining its business. Subject to all of the terms, the lessee hereby agrees to pay lease rent during the lease term on and from the lease rent commence date in the manner as stated in part 10 of annexure 1 to the lesser number 2. So, the money is going to the lesson number 2, to which the lesson number 1 has consented. The lessee shall be liable to pay the lesson number 2 revenue share as stated in part 10 of annexation. If the revenue share is higher than the lease rate, in the manner and subject to other terms, the lease deed during reconciliation process is part 3. The lesson number 1, that is the plaintiff, hereby provide consent and authorizes the lessee to pay to the lessee number 2 to collect the lease rent, revenue share, camp charges, security deposit, and or payments to the lessor number 2 as per the terms of this lease deed. Consequently, all invoices shall be raised by the lessor number 2 alone for the entire lease rent, and camp charges and all payments shall be made to the lessor number 2. Then is very important. Such payments to the lessor number 2 shall be a valid discharge of the lessee's obligation to pay lease rent, camp charges, and other payment as per the terms of this. I owe money to Merlin under that mortgage. We entered into an agreement for development. I have a revenue share of 52%. He has a revenue to share of 48%. By this deed, when the money comes in, I say you take the money. Obviously, the money goes to him in adjustment of the dues that I have. And it might come back to your lordship, my lord. That was the purpose of the agreement of development where it say we will commercially deal with the property and divide the net sell revenue. Net revenue. So this understanding is still there till 6th March. Now, my lord, kindly come back to the impute conveyance. 310 million. Needless to say, my lord, I was not there. So statesman was represented by Merlin. Merlin was represented by Merlin. And of course, my lord, the purchaser, my lord, in my case, is that the purchaser probably is also under the control of Merlin. This is my case. Now, let's see how he expresses his right to sell.
So as an author, okay. Who has signed on behalf of the statesman?
Statesman is also Merlin. Your lordship comes, my lord.
Yes, authorized signatory of Merlin. Yes, next.
My lord, kindly, my lord, come to E, page 314.
Yes.
The owner has executed a power of attorney in favor of the constituted attorney. Your lordship has got it, my lord, D. Above named, acting through its authorized signatory named above on 26th March 2019, which has been registered at such and such, your lordship can skip it. And by virtue of the said power of attorney, constituted attorney is internally entitled to undertake development and to do all needful, including sale, transfer of constructive place, together with land comprising the project, and to execute, register the sale deed for the same. It completely suppresses the fact that the decision was that it would be jointly dealt. That is not there. But that is a fraud which has been practiced by the defendant number 1 on the defendant number 2. I'm just showing that where he is deviating from the obligations which are coming in his way. So he doesn't indicate that there was a agreement to jointly develop. Then, in terms of the development agreement, as per the sanction and revised sanction plan of Kolkata Municipal, developer has completed addition and alteration of the existing building for the mercantile purpose, including construction of a new parking block at the premises, and has obtained completion certificate on 14th of May 2025 from the Kolkata Municipal Corporation. So May he gets a certificate and he sells it in the month of July. If the owner intends to retain built-up space measuring 1500 square feet more or less on the third floor of the existing building for its office purpose, hereinafter referred to as the owner's retained area, it is pertinent to note that the said premises has been mortgaged to the developer with a registered deed of mortgage dated 26th March 2019. The said mortgage stand released by this present, and the developer shall adjust from the sale consideration amount mentioned hereafter all its receivables from the owner. So this is a letter, or this is a clause which he says
all are finished.
That so far as the mortgage is concerned, I am, my lord, exercising my right. My lord, what I'm trying to say, he is exercising his right to sell the mortgage property.
Perfect.
And this is where he exercises his right. So he falls on the mortgage thereafter. The owner has taken various loans and advances from the developer time to time, and further certain expenses were incurred by the developer on behalf of the owners relating to payment of corporation tax, office shifting expenses, CEC bills. To fix the modality of repayment of the said loans and advances mutually agreed consideration of above mentioned developer share, there was a meeting held of the owner and the developer on 10th May 2024 at the office of the developer. In the said meeting, it was agreed and recorded that the owner will comply with its obligation of payment of aforesaid amounts within 15th July 2024. Kindly, my lord, mark this date, 15th July 2024. I have said that I'll pay him everything. A copy of the minutes of the meeting is annexure 1 to this present. My lord, has your lordship ever seen in a conveyance a minutes is annexed for the purpose of showing that I have the authority to sell? The reason why he is doing it is because he is trying to collate to get an impression that I am selling. It's a clear marketable title. If I have, I'll say I have a clear marketable title. You check my title and take it. but he's trying to explain how he has a right to sell. Thereafter, however, the owner has failed to fulfill its commitments of making payment to the developer in terms of the minutes of the meeting, and as per clause C as appended below, the developer is entitled to deal with the project without any further consent from the owner. But he set out this clause. I am not reading it because I'll place the tense minutes which is there. Then the developer along with the owner in the meantime have jointly granted lease. That is the lease of part 10 which I just placed in respect of some portion of the constructed area units of the said premises in favor of a prospective lessee for operating retail stores. Details of the said lease is more fully described in the third schedule. The owner is obliged to the developer, owner is obliged to, and the developer is entitled to sell and are hereby selling, transferring the entirety of the said premises as more fully described in the first schedule hereunder written, excluding therefrom the owner's retained area as more fully stated in the second schedule, which is below that 15,000 square feet only, and hereinafter referred to as the owner and duly demarcated in the plan annexed in such and such at a total consideration of 235 crores as per the sale agreement executed amongst the parties herein. The agreed total consideration is inclusive of stamp duty, registration fee, such and such, such and such. The sale of the project is on as is where is basis and free from all mortgage charges subject to lease as aforesaid. Then Millard, this is Millard. Thereafter Millard, now this indenture witness it, 2 crore 35. So Millard, three things appear from this conveyance. 2 crore 35 was, Merlin says, as a developer, he has a right to sell under the development agreement, read with the power of attorney, and the 10th minutes and the mortgage. Now, Millard, I'll show to your Lordship, Millard, prima facie, that none of these documents can give him a right to sell. But before I do that, Millard, kindly come to the minutes of 10th.
Where is that?
Page 326, I'm sorry.
Yes.
Minutes of the meeting held on 10th of May. This is Millard, the minutes that they were referring to.
Yes.
Millard, your Lordship will find my chairman and managing director was there at the top, and Sushil Mehta. This is Millard, where he is. Statesman House, Kolkata is being redeveloped as a mall by the developer pursuant to the registered agreement of March 2019. Although it is initially planned by the developer that the redevelopment of the project will be completed within 42 months from the commencement of construction, or the structure of the old building was found in a poor condition. Then came COVID-19. As a result, efforts were not possible to complete the project within the installation. The owner acknowledged the efforts of the developer to reduce the Statesman building in spite of having many challenges. Acknowledges the fact the construction is on the schedule is satisfactory. The owner and the developer hereby agree as follows. The owner has agreed to purchase, that means Statesman has agreed to purchase and acquired the right of the developer's share of revenue accrued under the agreement of 26 May 2019 in the Statesman House project at or for a total lump sum consideration of 130 crore and also refund 30 crores paid by the developer to the owner against agreements both dated 26 March 2019, and the same will be paid in the following manner. So I have agreed to purchase 30 crores for the deposit and 130 crores his share. Within 15th August 2024, page 327, I'll pay him in the following manner. 55 crores on receipt of completion certificate and execution of requisite document including sell deed, 75 crores and 30 crores. The 75 is the balance of his share and 30 crores below was the mortgage amount.
Why the receipt of the company execution of the requisite document invoice? Why the sale deed?
Below the sale deed is because the owner was trying to, Statesman, the plaintiff was trying to purchase him out.
It is your property.
No, but he had that 42% share.
So it is only agreement. It has not. Only
Correct.
the agreement is to be.
So therefore, that sale deed would actually mean that he will let off his 42% right, whatever he had on the land after construction, to give it back to me. So it will be 75 lakhs and 30 lakhs is for the mortgage. Milord, your lordship, milord, will thereafter see the owner has agreed that apart from the aforesaid amount of 160 crore, further liable to pay the developer the following amounts. Milord, these are on account of CSC dues. This is for office shifting expenses. These are administrative. Milord, expenditure payment level on account of owner's share, KMC tax, such and such. The aforesaid amounts as mentioned in clause B, subclause 1, 2 and 3 above is payable by the owner to the developer on or before 15 July 2024. In the event the owner fails or is unable to fulfill its commitment of payment of any of the aforesaid amount mentioned in clause A and or clause B above, and the loans and or advances together with interest, the developer will automatically be entitled to dispose of the project in entirety for recovery of all its dues at its sole discretion, and in any manner whatsoever without any reference to the owner, and the owner consents not to raise any objection whatsoever with regard thereto, and also extend necessary cooperation to the developer in this regard, and in turn the developer will act to the best of its ability. The developer at its sole discretion would be entitled to deal with the project in the manner, deal with in any manner the project or to any one of the purchaser, lessees or the like of its choice, and a consideration to be solely decided by the developer. And further, the developer shall, after retaining all the amounts payable by the owner to the developer to it as mentioned herein above, together with interest calculated till the date of receipt of the amount, thereafter make over the balance to the owners. So this is where he says that there is a contract which gives me a right to sell, and he exercises his right to sell not on the basis of this document but on the mortgage deed. The reason why I say so, milord, kindly milord take the development agreement. The development agreement, no, that's change. Finally, we will come to clause 23 at page 103.
Yes.
Kindly see, Millard, amendment modification.
Yes.
No amendment or modification of this agreement or part thereof shall be valid and effective unless it is by an instrument in writing, executed by all the parties, and expressly referring to the relevant provision of this agreement. Now, Millard, so far as this is concerned, this is a registered document. So, no part of this document can actually modify my rights under the development agreement. But I am not saying that I have not signed this. I have signed this. So that is the reason, Millard, when he realizes that under the development agreement he doesn't have a right, he is bringing in the mortgage. Because under the mortgage, if he has a right, if I don't pay him, he has a right to sell.
Correct.
And that's why he has done it. So therefore, Millard, in the conveyance, his right to sell flows from the mortgage. Kindly come to the mortgage deed once, which is, Millard, at page 163. Millard, 163 it starts.
Yes.
Millard, recitals your lordship can skip, not of much relevance, because at that point of time This is only a loan, and this is also a registered document. This mortgage is also registered.
Yes.
My lord, in pursuance of the consent letter of the mortgagee, and in consideration of sum of rupees 29 crores advanced by the mortgagee to the mortgager, the mortgager doth hereby transfer, convey, assign, and assure unto in favor of the mortgagee all the singular.
Where from you're reading?
My lord, page 168. I'm sorry, my lord.
Yes.
In pursuance of the consent letter, my lord, now this deed witness it. In pursuance of the consent letter of the mortgagee and in consideration of sum of rupees 29 crores advanced by the mortgagee to the mortgager, the mortgager doth hereby grant, transfer, assign, unsure unto in favor of the mortgagee all and singular the said property which is in the custody, control, and possession of the mortgager, more fully described in the first schedule, and the estate right, title, interest, and all the estate right, title, and demand of the mortgager in or upon the same or any part thereof, to have and to hold the said property upon the mortgagee absolutely, kindly mark, subject, however, to the proviso for redemption hereinafter contained as security for repayment of the sum advanced by the mortgagee to the mortgager with interest as hereinafter specified. So, my lord, obviously all mortgages contain a redemption clause. Then, my lord, kindly come to clause 2 at which 169.
Yes.
To secure the due repayment of the said sum as aforesaid, the mortgagee shall hand over to the mortgagee shall hand over to the, it should be the mortgager shall hand over to the mortgagee the original of the title of the said property described in the second schedule hereunder written, as and when the same shall be available to the mortgager, who shall be entitled to hold the same till the mortgage dues are paid or satisfied by the mortgage. And the mortgager hereby covenants with the mortgagee as follows. The mortgager shall pay to the mortgagee the principal sum of 29 crores in terms of the consent letter of 25th March 2019. Consent letter to print of the Millard, the consent letter was not made part of it, Millard. But then notwithstanding anything contained in clause 1 above or elsewhere, or in any other document, the whole of the loan shall be so desired by the above or elsewhere in any the whole of the loan shall, if so desired by the mortgagee, become forthwith due and payable by the mortgagee upon the happening of any of the following events, and the mortgagee shall be entitled to enforce the security subject to prior notice to the mortgager. Any violation of the terms as per the consent letter, the mortgagee committing any breach, the mortgagee entering into any agreement. So these are the 4 conditions. Kindly mark, my lord, there is no date for payment, and there is a good reason for this. The reason, my lord, is this: if you want to sell a mortgage property, you will have to mandatorily give a notice, irrespective of whether it is written here or not, that I am calling upon you to pay this debt. Unless you give me that notice, which is a statutory mandate, the debt does not accrue. Now, not only the notice is there, my lord, so the question now arises is, if you are entered into an agreement for sale on the basis of the mortgage deed, did you comply with the terms? My lord, it refers to a consent letter. I don't want to be, my lord, alleged for suppression. My lord, this is what we have. My learned friend will correct me if I am wrong. No. Your hand would reach till there. Your hand can only reach. This was the consent letter which refers to Millard. But Millard, I have an unsigned copy. My learned friends clients would probably be able to produce the signed copy. This is to the different. I'm part of the process. So Millard, this is the whole story. I have, after coming to know Millard, they will be relevant thereafter. I have cancelled the power of attorney. I have cancelled the development agreement.
When you are cancelled?
Millard.
After the deed?
Of course, when I come to know, because I didn't know that. Prior to that, you have sold. And I made a police complaint that there has been a forgery.
What would be effect of this minutes of the meeting?
I'm coming to that. I'm coming to that. I knew this will come, Millard. Obviously, the minutes is, Millard, there are 3 documents. we may consider. One is the minutes, one is the mortgage deed, and the other is the power of attorney. So far as these minutes are concerned, this minutes your lordship will find was at a time when I gave him an offer to buy him out. And there is a clause that if I don't pay him these amounts, which includes the mortgage deed and his share of 1 crore 30, then he will have a right to sell without having recourse to me. He didn't have to come. Now, at the best, what can this be? This can be treated as a subsequent agreement to the development agreement, because the development agreement was not modified. This 10th minutes does not say that this is in modification or supersession, or this has to be read along with the mortgage, number one. So this cannot be read along with the development agreement, because those are all registered documents, number one. Number two, it can be a contract where my learned friend can at the highest say that I have a right to sell without putting him on notice. That's the only thing he can say. And by virtue of this clear right given to me, I need not have given him notice, I have sold it. That presupposes that he has a right to sell under an agreement which is registered, because it's an unregistered document. Now, before I go to, can you come to the notice first? Because if he doesn't have the right to sell it without notice to me, the sale is bad in law. Now, transfer of property.
This minutes of the meeting with right.
This minutes of the meeting is neither here nor there. And I'll tell you, lordship, why.
With interest. If you say the with interest, right has been accrued in the...
It cannot create a right to immovable property. Milord, if I am to transfer title, I have to have title with me. Development agreement doesn't give him title. It only gives him a right to sign and execute conveyance on my behalf, which he has done. So to that part of the development, he has executed the conveyance. Where does he get the title from?
By the deed.
By
the
mortgage. So he gets the right to sell. He doesn't get a title by the mortgage, he gets the right to sell.
Correct.
Now that is where I'm trying to come. Well, kindly will take the transfer of property act. Will kindly come straight to 69. That your lordship has it 69. Power of sale when valid. A mortgagee or any person acting on his behalf shall, subject to the provisions of this section, have power to sell or concur in selling the mortgage property or any part thereof in default of payment of mortgage money without the intervention of the court in the following and in no others.
Correct. Yes.
A, where the mortgage is an English mortgage and neither of the mortgager nor the mortgagee is a Hindu, Mohammedan or Buddhist or a member of any other race, creed or class or any type, this is not applicable. Here is the mortgage by deposit of title deeds. My title deeds are with it. Where the power of sale without the intervention of court is expressly conferred on the mortgagee by the mortgage deed and the mortgagee is the government. So the power B doesn't apply to us. Then this is where the power of sale without the intervention of the court is expressly conferred by the mortgagee by
the mortgage deed, the mortgage property or any part thereof, situated within town of Calcutta.
Your lordship is reading
C.
Where a power of sale without the intervention of the court is expressly conferred on the mortgagee by the mortgage deed.
Correct.
and the mortgage property or any part thereof,
Yes.
as on the date of execution of the mortgage deed, situate within the towns of Calcutta, Madras, Bombay, or any other town or area which the state government may by notification of official specify in this behalf. Property is in Calcutta. The mortgage deed doesn't give him that right. Mortgage deed says you will have to give notice. This notice in the mortgage deed is what subsection 2 says. Here is the bar. No power, no such power shall be exercised unless and until a notice in writing requiring payment of the principal money has been served on the mortgagor or on one of the mortgagors, and the default has been made in payment of the principal money or of part thereof for 3 months after such service. So he has to give me a 3 months notice enforcing the mortgage. Some interest in the then Millard, the other requirement is some interest under the mortgage amounting to at least to 500 rupees is in arrear and unpaid for 3 months before becoming due. If these two things, if you don't give me a notice and you don't comply with 3 months notice, you don't have the power to sell.
What about the exemption? What about the exemption given in the minutes of the meeting?
Cannot. So it can. I'm coming to you. I'm coming to you.
P also should.
Yes, I know. So, Millard, Millard, I'll show the section says that the power to sell must be in the mortgage deed.
Correct.
Not by any other contract. Because I'll tell your lordship, this is a statutory right given to the mortgagor to redeem the mortgage till the last moment. Now, 3 my learned friend is entitled to it. When a sale has been made in professed exercise of such power. So this power is the power under subsection 1 to sell.
Correct.
Power under subsection 1 to sell will only come if you have a power, if you have given a notice under subsection 2.
No. When sale has been professed
When a sale has been made in professed exercise of such power. The power is, kindly will it come to 69.
Correct.
Power of sale.
Correct.
So if you want to exercise subsection 1 power, you will have to do it by giving a notice under subsection 2. Subsection 2 starts with no such power shall be exercised.
Until a notice in writing.
So therefore, this power is dependent on the notice.
Correct.
The reason why my learned friend is trying to, I'll place it, when a sale has been made in professed exercise of such power, the title of the purchaser shall not be impeachable on the ground that no case had arisen to authorize the sale, or that due notice was not given, or that the power was otherwise improperly or irregularly exercised. But any person damnified by the authorized or improper irregular exercise of the power shall have his remedy in damages against the person exercising such power. So therefore, it doesn't go against me, Millard. All it says is that you can validly defend the sale, provided you can show that the notice was given. This is regarding the purchaser. Correct. The purchaser can come and say that, look, I have a right, I have accrued a right because of this sale in exercise of power under subsection 1. I am saying that the subsection 1 and subsection 2 are to be read in a manner which says that if you have a right to sell, no problem. For that, you will have to give a notice. This 3 months notice, if it is not given, then in that event, power 1 is not there. If power 1 is not there, power 3 does not apply. And this will not be held. This will not be held.
So you mean to say the power 2.
Subsection 2
governs
subsection
1, and without the compliance, the 3 will not come in.
That's why it starts.
That's why
subsection 3
when the sale has been made, the professed exercise of such power.
So to exercise that power,
Yes.
you have to comply with 2.
Correct. Yes. Next.
Now comes Millard.
It will take further time.
Millard.
কবে করবে
That's why.
কবে করবে
Tomorrow?
কালকে করিস না
Tomorrow क्या है?
Continuity টা থাকে। Anyway, Millard,
hopefully not tomorrow
I don't want to take it beyond that. Millard, I'll let
Monday কর না
Millard, I can before
after
leaving for
Independence
vacation,
Day
Millard,
after
before
Independence Day would
I need
be a
to
very
get
good
rid
idea
of-
Malo to come back and argue this matter
I get to rid of the burden, Millard, before I go for the vacation. Thereafter, Millard,
Independence Day পরে Monday কর
Millard, of course, is subject to.
क्या है? Monday क्या है? साढ़े 10 बजे। हाँ। ठीक है, इसको रख दो, फिर उसके बाद देखिए। Yes, Monday.
Grateful.
Counsel for the plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on Monday.
Grateful.
Yes, call the matter.
My lord, so far as before the witness gets in the box, the list of exhibits, এক মিনিট দাঁড়া, আমার ম্যাটারটা অলরেডি কল করে দিয়েছেন।
I will let them because already delayed.
My lord, so
Yes.
far as the list of exhibits are concerned, my lord, I have already discussed it with my learned friend on the other side. So this may be kept on record and may be made part of the order today. This is the list of exhibits of documents through the tendered through PW1, my witness. It's admitted. The documents which are admitted.
What happened was a particular serial number was given to the affidavit of evidence, but then disputed documents were tendered. So serial numbers have now
changed.
So this
So
is
this-
the new exhibit number. These are admitted documents.
Yes.
If it can be made part of a order subject to your lordship.
So this has not been exhibited.
No, this has been exhibited along with the questions against the question numbers, but
with the
formally the list of exhibits may be kept as part of
No,
record.
इसमें exhibit क्या हुआ?
Not by putting questions.
Not by putting questions because it's a commercial suit.
Exhibit M.
এই নাও, তুমি একটা তাও রেখে দাও, তোমার অনুপত্র দিয়ে দাও।
And so I'm already there.
Everything is
exhibit
on
M.
record,
Ah.
but your lordship, there are other exhibits also
Ah.
which are on the basis of the admission made. So these are the admitted documents, and because it's a commercial
Okay.
suit,
Okay.
the documents were tendered by way of his affidavit.
Okay.
The cross-examination may begin after keeping this on record.
Up to M was exhibited formally, and so this is the rest of the documents.
इसको ना तुम उसमें नोट कर लेना। Exhibit.
Well, may I begin?
Cross, huh?
How did the plaintiff come to know about the defendant number 1 company? How did the plaintiff come to know about the defendant number 1 company?
My honor, just to enter a new business, I went to several trade fairs where I came to know about this this company.
Came to know about this dependent company.
When did you, for the first time, submit your proposal with the defendant number 1 company?
I did not actually. I contacted them in the month in the year.
Actually, I contacted.
Actually, I contacted them year 2012.
Would it be possible to specify the month of 2012 in which we contacted the defendants?
No, I have to go through the emails, then I can confirm that.
I have to go through the emails, then I can confirm.
And when you approached the defendant number 1, what was the proposal that you had submitted to them?
Actually, I contacted them that I want to get into this business and want to put this plant and machinery for manufacturing of cosmetic tubes, which is widely used among all the cosmetic companies, not only in India, but worldwide. And the same tube is also used by medical industries, is used by medical industry as well.
Before approaching the defendant number 1, did you make a project report for this factory you have just spoken of ready?
Not actually, because the project report has been prepared during the discussion while the discussion was going on with them. Because I am totally new in that business. I have new in that business, and I have no know-how about this project. So I was totally dependent on them. Whatever inputs I used to get from them, I get from them. On the basis of that, the project report has been made.
Did you not in your emails intimate the defendant number 1 that you would be needing machines of particular specifications and customizations?
No, in any of my email, I haven't mentioned any particular specifications because being totally novice in this trade, I have no idea. So on the very first discussion, I informed that I'm totally new in this business, and I found this business lucrative. I found this business a lucrative one because there were only handful of manufacturers, approximately 11 at that time in India.
Kindly come to paragraph 6 of your affidavit of evidence. At page 4 and 5. Can you say who Mr. Ashim Nandi is?
Mr. Ashim Nandi was my employee during that time.
Can you give his designation?
In my firm, there was no such as designation. No such designation.
Can you kindly take the list of exhibits submitted along with the affidavit of evidence and come to page 12 thereof. Is this an email issued by Mr. Ashim Nandi?
Yes, my lord. This email has been issued by Ashim Nandi.
Can you tell my lord who is my customer? My customer would be within single quotation. Who is my customer whom Mr. Nandi mentions in the email?
Uh, my lord, I I don't know who is referring to him to as my customer because as my customer because he works voluntarily to other companies for other companies as well.
That this has subsequently been numbered as Exhibit S today.
Exhibit?
S. So,
Page 12 and 13. 12, 13.
page 12, Exhibit S. If today S.
S.
Exhibit S.
And would you be able to say which company Mr. Nondi was referring to as this company in the second line of the email?
My lord, it can be me or some other company as well because as already I informed you that he works voluntarily for several companies. So he might be asking for me as well as another company as well.
Another company as well.
Kindly come to paragraph 8 of the plaint. Plaint টা দেবেন। Can you tell, my lord, was any discussions as mentioned in this paragraph held at the office of the plaintiff?
My lord, all this discussion has been held in my office, which is at 14 NS Road, 4th floor, Kolkata 1. Yeah.
And who had participated in such discussions?
Myself, Amit Agarwal, owner of the supplier company GCM, Mr. No, KNOW. Sorry, it's a KWON, Mr. No, pronounce as No. ON, and his Indian agent, Mr. Urmesh Singh. Urmesh Singh.
Can you say the specific timeline of these discussions?
More or less, it was near about in the morning, near about 11 o'clock.
On which date?
That I have to look in their proposal, which that I have to check.
Would you be able to check and tell now?
No, it will take some time.
Is it your case that Mr. No came to your office and the agreement was concluded at your office?
Mr. No came to my office. We discussed about all the terms and conditions for setting up this project. On that basis, I received his proposal on my mail at my Calcutta office at 14 NS Road, 4th floor, Kolkata 1.
So, would I be right in saying that the meetings, discussions, and agreements referred to in paragraph 8 of the plaint were not the final agreement and was followed by a subsequent proposal and further agreement?
Not actually. On the date of our first meeting, we discussed everything. Later, Mr. No sent me all the copy of agreements, machine supply details, performer invoice, etc. After going to his country and was accepted duly by me at my office at 14 NS Road, 4th floor, Kolkata 1 through mail. At that time, he told me that he will send over email, which I need to confirm through mail.
Kindly come to page 337 of the judge's brief of documents. Is this the email by which Mr. No had forwarded his offer to you after the discussions referred to in paragraph 8 of the plaint?
My lord, there were several emails has been exchanged with the same content because each and every time Mr. No was changing some of the terms which we have agreed upon during our meeting. So, particularly looking at this page, I cannot confirm whether this is the first correspondence by them or the final one.
Mr. Agarwal, in answer to a previous question, you said that after the meeting, Mr. No went back and
Went back
to his country and forwarded his proposal to you. Such proposal was forwarded by way of an email. Was such proposal forwarded by way of an email?
Yes, in that proposal, it was containing firm offer, delivery schedule, firm offer, delivery schedules, machinery details, performer invoice, etc.
Have you disclosed such email containing the attachments as you have just deposed in these proceedings?
Yes, my lord, all these documents has been disclosed.
Can you point out the documents from the exhibits or the judge's brief of documents. Well, I'll just modify the question. Can you point out the email and the documents?
My lord, only these are the documents which are having copy over here. And this page number 337 and the continuous further and the continuous of these pages. The attachments are there. From 337, from page number 337 to 345, which were duly submitted as per requirement in due course of proceedings.
Well, this is part of my disclosure, but since he has identified and is admitting these are the documents, my lord, I was humbly submitting this could also be marked as exhibit.
This has not been exhibited document. This
It is not forming part of list of info.
this is not the exhibited document.
Well, because these are my disclosures, I will be bringing my witness to exhibit my documents, but this is one document he is admitting. He has identified the documents, referred to the page numbers. This can be marked as exhibit.
What the page number?
337 to 345.
Witness identified the documents appearing at page number 337 to 345.
My lord, let this go subject to objection. Why? I'll just indicate. Witness, if the witness is asked to go out, then I'll indicate, because otherwise he might, I might
Absolutely.
subsequently said that I have indicated or given sufficient indication to the witness. If the witness is asked to go out,
Yes.
আপনি একটু কোর্টের বাইরে যান, আমি একটা সাবমিশন করে আপনাকে ডাকছি। My lord, as the witness has deposed in one of his answers, I believe he has said that there was many emails which were exchanged, and over the emails firm offers etc were exchanged, for which ultimately culminated into the agreement. What your lordship will find at page number 337, it doesn't have the covering email. Therefore, this firm offer, whether it forms part of any particular email, he has only said, yes, all these kinds of documents were exchanged over mails. But whether at all this is the one which was shared over mail, because the covering email is not disclosed by the defendant. Only limited to this, let my objection be taken on record. I'm not standing in the way for marking of the document, but let it be marked as for identification, not
but
marked
the
as an exhibit.
My lord,
No,
my
but
lord will
witness
kindly.
stated that what is the last answer?
Well, just to answer to
And also
the
the
last
question, my
answer,
lord, he
yes,
was asked to
Yes.
point out.
Yes, but উনি মেলের কথা বলছেন
He did not directly answer, my lord. Then I had put a question to him.
No, he has identified the document from page 337 to 345.
345.
These are the correspondences.
But this actually doesn't have the covering email.
He has admitted that.
Then at least it may be marked, but subject to objection. I am objection only because the covering letter is not there.
Witness has
Witness has said also, in if your lordship kindly
He's
looks into his
objecting to
affidavit.
his witness's
if-
disclosure.
May I make my submission? if your lordship will kindly look into his affidavit on evidence once, because in his affidavit on evidence, he has said 3 paragraphs are relevant. Paragraph 18 onwards, if your lordship looks into, at the stage of negotiation, defendant number 1 represented machine lead time, etc., etc. Then December 4, GCM wrote to plaintiff for its confirmation on modified terms of contract. Then lead time taken, so and so. Emails were exchanged. He has given the details. Then paragraph 20 says, after prolonged discussion and exchange of emails, defendant numbers 1 and 2 agreed to sell and deliver, which ultimately culminated basically into the contract and which was shared over mail dated 13 December 2012. So the ultimate contract was entered into on 13th of December 2012. Now, whether this is dated, the firm offer is dated 11 December 2012. I'm just putting the question to myself whether it can be identified from the document that it forms part of that very correspondence or not.
It is not with regard to that, it is with regard to the connected. Only stated that these are the correspondences which he has received. So it's only identified the document for what purpose is not stated, and the court is not going.
Very well. As per your lordship's direction, then it may be marked as.
Yellow. No. Page 337 to 345. Page 337 to 345 on marked exhibit 1. 1 collectively होगा.
What was that? Mr. Agarwal, kindly come to page 346 of the judge's brief of documents. 346 of the judge's brief of documents. Can you tell, my lord, is this the agreement which was entered into between the plaintiff and the defendant number 1?
My lord, as I told you that there were several times the contract has been remodified as Mr. No was keeping changing the terms as we discussed with them. So I am not 100% sure whether on this agreement has been we have finalized or the another amended one. And my lord, in the context of ma'am's previous question that when we met him at our office, I just found a paper in this brief. Can I tell her the date?
What?
Ma'am asked me a few minutes back that when we met him at my office.
Witness volunteers. Yes.
We met at our office on 19/9/19/09.2012.
Yes.
Paragraph 8 paragraph 8 answer. Mr. Agarwal, was any formal agreement entered into between the plaintiff and the defendant number 1?
Yes, there was a formal agreement, the last one which we agreed upon.
And have you disclosed such agreement in these proceedings?
Yes, that is also disclosed during these proceedings.
Can you please point out such agreement from the judge's brief of documents?
That,
point out such agreement from the JBT.
my lord, that at the moment I am not able to do because I have to at the moment because I have to look all the mails exchanged among us. After that, I can confirm.
Confirm. I can.
Since you are not able to identify the formal agreement which was entered into between the parties, would I be right in saying you would also not be aware of the final terms which were agreed between the parties?
No, ma'am.
Lordship, no, your lordship.
No, no, lordship.
So are you aware of no?
What was your question?
No, because he answered no.
Wait,
So
what
you-
was the question? What was the last question?
একটু পড়ে দিন ওনাকে। Since you were not able to identify,
Final terms agreed.
Can you able to identify, say the final terms of the agreement or not? That is the only.
My lord, I can identify, but I have to check the mails because each and every time he was changing the terms and conditions and sending again and again. So is this that the particular final one or not? That I have to check to all my documents after that.
He is changing again and again the terms and conditions. That's why unless I can check the documents and mail, I cannot confirm which is the final document, final agreement. Yes.
was payment of the first installment of the advance payment not a condition precedent to the commencement of any work by the defendant number one?
No, my lord. Actually, the first payment was conditioned against the supply of entire plant and machinery within 5 months from the date of the first installment made to them.
In your affidavit of evidence, you have said that the defendant number 3 approached your company for a job. Have you ever informed the same to the defendants number 1 and 2?
My lord, I haven't informed defendant number 1 and 2 because defendant number 3 has requested me that not to disclose them as he is associated with them.
Can you say when the second installment of the advance payment was payable by the plaintiff company?
That I have to check the mail and remittance slip. After that, I can confirm.
I am suggesting to you that you are not aware of the agreement between the parties.
No.
Then
I do not agree with that.
Then kindly say when the second installment was to be paid according to the agreement between the parties.
My lord, as earlier I told you,
Take leave of the court. I was just informing him, take leave of my lord if you have to look into documents.
my lord, as earlier I told you that it's already a very long matter. I have to, until unless I won't see that agreement, commenting anything will be wrongful.
Yes.
No, it's on record. Would you agree with me if I say that for enabling the defendant number 1 to fulfill its obligations under the agreement, timely payments were crucial?
No, my lord, nothing as such was there because only the main condition was that machine would be supplied within 5 months from the first date of installment or first installment only.
Would you agree with me that for manufacturing the machines, the defendant number one needed to purchase parts from third parties?
No, my lord, as it's their job, how would I know that? Their job to make the machineries, how would I know that?
Was the same never informed to you by the defendant number one by way of email?
No, my lord, I did not remember anything as such because such discussion never happened with them, whether they will buy the parts from someone else or they never any parts from someone else to build the machine or they have there in stock. Neither I asked them.
Kindly come to paragraph 24 of your affidavit of evidence at page 12. Why do you say that the delay in making payment of the second installment was beyond the control of the plaintiff?
My lord, as this is a foreign remittance, there are some rules and regulations which I came to know during that time only, which has to be adhered by the bank who needs to send the payment. In which I have no role to act on. That's why I have said that in remittance of second installment, I have no litigation on myself.
No.
No any litigation on myself. It's not my duty to pay it's actually duty of the bank to issue the payment.
What is your contention? What is stated? Which has to adhered.
Adhered to by the
Adhered by the bank.
role to play.
No role to play. No remittance of no burden. It's no burden.
But prior to payment of the second installment, you had already made payment of the first installment. So you must have been aware of the rules and regulations which you have just. But prior to making payment of the second installment, you have already made payment of the first installment. So you must be aware of the rules and regulations relating to payment to foreign entities.
My lord, as this is the first foreign remittance personally handled by me, I was not 100% aware of the foreign remittance. And when I approached the bank for the second installment, only that time they informed me that you can remit any kind of foreign remittance once. If you have to send again, then there are sums again. there are some rules and regulations which bank have to follow, and it will take time.
Yes.
Are you saying that these rules and regulations weren't required to be followed the first time you made payment to foreign entities?
That bank can only say. My lord, that bank can only say.
The bank can only say.
Did the bank make any such representation to you?
No, my lord, they did not do anything. But when I requested for the second remittance, they just conveyed me verbally.
What did they convey you verbally?
That some regulations, documents they have to prepare before remittance.
However, such regulations were not required to be complied with, or documents were not required to be executed when you remitted the first payment. Is it what you are saying?
Please come again.
Regulations were not required
to be complied with.
My lord, I don't know about such regulations as nothing was informed me by the bank.
Who handled the payment of the first installment? Was it you?
My lord, it's all been done by my employees on my instruction. I just instruct them that this payment has to be made.
So you had not personally spoken to the bank officials. Your employees have. Am I right?
Yes, my lord.
Can you name the said employee you just referred to?
My lord, to be true, I hardly remember because it's already more than 10 years.
Can you say what was the percentage of the total contract price which was agreed between the parties that was required to be paid by the plaintiff in advance?
My lord, not in terms of percentage, but in terms of amount. But in terms of amount, I can say that I have to pay them 2 installments of $150,000 each.
And what was the agreed contract price?
My lord, if you allow, can I just check the record? As far as I remember, it's $12,05,000.
You want to see the document?
Yes, my lord.
Sure.
page
165.
Page 165. The witness refers to page 165 of the plaint. Amount page
12,05,000. Page number 165 of the plaint. Final amount is 12,05,000 US dollars.
And this is also appearing at 288 of the judge's brief of documents.
Yes, next.
Just give me a minute, man. I'll just take out 288. Mr. Agarwal, what is the document which is appearing at pages 287 to 291 of the judge's brief of documents, from which you have 291, 290, it is up to 290.
My lord, the pages number 287 to 290 is the copy of the contract. Again, from page 291 to 294 is also a contract between both of us. So which one is the final one? Until and unless I won't go through, I cannot say that which one is the final contract.
True court. Both the document does not contain any dates.
No, my lord, I cannot locate any date in these documents.
In both the document?
Yes, my lord. I am not able to locate in both the documents.
Yes. Next.
Mr. Agarwal, can you say why you have filed the instant suit?
My lord, actually the agreement entered between us was to supply the complete plant and machinery for this new business and 100% guidance from their side. And it was supposed to be supplied and get the installation done within 5 months of the first date of first installment, which was not adhered by them, and being a buyer and making the payment is totally pointless. So I filed this suit against them.
And you are not in a position to identify this agreement on the basis of which you have filed your plaint case. Am I right?
No, my lord, as already I told you that I am able to identify, but before that, I have to go through my all emails. After that, I can say.
Well, may I come back, because I'll only need half an hour, maybe another day.
Okay. Where from? He's from here only.
Sorry,
Witness is from here only.
he's from here, but he keeps on traveling as per his availability and as per my learned friend's availability.
Plaintiff witness is present. Plaintiff has filed the list of exhibits with regard to the documents which have been exhibited through PW1, being exhibit N2 AAA. Let the list of exhibits be kept with the record. Plaintiff witness is present, cross-examination resumed. And during his cross-examination, bunch of documents have been marked as Exhibit 1 collectively. Due to paucity of time, cross-examination of the witness could not be completed. Accordingly, cross is deferred. Let the matter appear on. How much time will it take?
Any day as it commences.
No, how much time? Because if
7 days, 7 days, 10 days.
No, no. Cross
Half an
examination.
hour, half an hour,
Half an hour.
maybe 45 minutes like today, my lord. Depends on.
11 September at 3:45. 11 September 3:45.
But can it be if it commences to
And just prior to
30 p.m.
the annual vacation.
Before vacation, I don't think anything.
2 p.m. If 2 p.m. is there,
That is
12:30 any day, my lord.
12:30.
12:30 is
12:30, my
also.
lord.
12 September 12:30.
Grateful to Rich. Yes, sure. Sure.
Yes.
Grateful to Rich.
Yes.
Let us. I would here. Hello, this is my suit.
Yes.
I'm appearing for the plaintiff. And my lord, there are applications on board. Lordship, this was part heard by your lordships, hence it's appearing before your lordships now. My lord, there is a GA2, which is, my lord, my application for judgment on admission. And my lord, pleadings are complete in the matter, my lord. And thereafter, my lord, there's a GA5, my lord, which was filed, my lord, because GA2 was dismissed for default. It has been restored, my lord, so that application need not be taken up. And my lord, there is a GA9 that has been GA8. GA8 has been filed by my learned friend, my lord, for dismissal of GA2. That is my application for judgment on admission. And they have also filed a GA9 for, my lord, introducing their witnesses, court witnesses. So, my lord, in respect of GA2, my lord, the matter was, my lord, dealt with by a different set of advocates previously. That we have instructions that submissions were already made by us. And, my lord, today is fixed for my learned friend to make his submissions in respect of GA2. And, my lord, then we can also file our written notes, my lord, after the submissions are concluded. And, my lord, I will also give my reply. Since I was not there when the submissions were made by us, my lord, if my learned friend submits today, I will take notes.
My brief submission is in respect of GA2, that is based on a document which was wrongly served upon them, but it was not filed before the court. Written statement, based on a written statement which was not filed before in the court. And after that, a cost was imposed by the budget master. I paid 100 GMs, and subsequently the matter was referred to judge. I forgot the name. Justice who imposed justice. I forgot. Who imposed a cost of 200 rupees with liberty to file a fresh written statement, and fresh written statement has been filed. Based on that, the GA2, their application, they have chosen not to file a fresh application in respect of my fresh written statement. Number 1. Number 8.
Yes.
GA8 is in respect of the.
No, GA2 already.
The affidavits are not complete in respect of the fresh.
GA2 hearing is going on.
Yes, my lord. My lord,
Mr. Banerjee had argued the matter.
I am not
But
sure.
he has argued, but it was not completed, and my difficulty is that my sister-in-law, elder brother's wife, is on Santhara for the last 19 days. Today is her 19th day, so I could not contact my counsel. So I would like to pray for some 2 weeks adjournment, because My elder brother's wife is on Santara, that is fasting for the today is the 19th day. So I would like to pray for 2 weeks adjournment. In the meantime, they will also, the new advocate has been engaged by the plaintiff.
My lord, we have, my lord, with all due respect, my lord, to my learned friend, my lord, this matter has been adjourned for a long time at their behest.
Also, it was heard by you for 3 days and
Last argument was made on November 13.
Yes, my lord.
13th November, the argument was made. Subsequently, then matter was fixed on 11th December. Counsel appearing for the defendant, press for time. Then 22nd January, counsel for the defendant, press for time. Then 26th of March, as per prayer made by the counsel for the defendant, case is adjourned. Then 20th June, prayer made by
continued hearing for the almost 3 days.
correct. And that's why I am having the notes. June 2024, the matter started. Argument is started.
My lord, this was not-
26 June 2024. 1 year has been passed, but one application. This I think this is a Guinness Book of World Record of this court number 38.
My lord, I am very sorry for that. I would like to pray for 7 days adjournment because
Yes.
7 days adjournment because I could not take.
Where is your advocate?
I could not contact her. For the 19 days, I am busy with my sister-in-law's house. For 90 days.
19 days you are busy in the sister's house. No problem. I have also very sorry to that. But with regard to that, the date was fixed on the last date was on 20th June. 2 months has been passed. The last date was fixed before this court on 20th June.
Submission is their application is based on a wrong document which was wrongly filed by me. And a fresh written statement has been filed upon payment of the cost by justice and the masters. 300 GM I have paid the cost for, and subsequently I filed the.
Correct. I know whether the earlier written statement which you have filed, which you admitted the claim of the plaintiff, whether that is to be taken into consideration or not by deciding the application under Order 12 Rule 6. That is the question.
Yes.
That is the question.
Yes.
So
earlier, subsequently, I have filed a fresh written statement for which they have chosen not to file any application in respect of the my.
So what will happen to the earlier the written statement which you have filed? What would be the effect of that?
Sir, my lord, I was given liberty to file a.
Okay, you filed might have been filed, but what would effect of that, which is already on record?
It is not on record, my lord. It has not been filed in the court.
You have served by way of communication.
Yes, by way of
By way of communication, you have served.
There is a subsequent communication also where they have filed the new written statement,
whatever
but
it
they
is,
have
that is
not
the point.
recalled the previous one.
Okay, that is the point of argument.
Yes,
Now, what is the submission now today?
Today, my lord, I have not could not make a conference with my counsel, and for that I am very sorry and pray for 7 days, at least for 7 days adjournment. Because I have been busy in my sister-in-law's house for the last. They stay in Rajarhat.
Yes.
Well, if Lordship my lord, grants me, I'll pray for an imposition of some cost, my lord. This is setting a bad precedence.
And counsel for the defendant, due to his personal reasons, prays for time. Accordingly, for the interest of justice, the case is adjourned. Let the matter appear on 26th of August 2025. It is made clear that on the date fixed, no adjournment shall be granted.
Grateful, Lordship. My lord, one indulgence, Lordship.
22nd. 22nd.
My lord, one indulgence, Lordship. My lord, there are a set of judgments which, my lord, was relied upon by the previous councils. I'm not sure, my lord, if the copies of the judgments are with my lords. If it is not there, I shall provide fresh copies.
Okay, come on.
I will. Grateful, Lordship.
Obliged.
22nd.
There is a time fixed.
Because this non-commercial matter at 2 p.m. it will be taken at 2.
Grateful, my lord.
Obliged.
इतनी यहाँ नहीं है ना, ये तो खाली बाकी हटा
It's like in the seventh schedule, shall be.
Milad, will Milad give this time to me, Milad, so that I can finish off item number 12, Milad, my part of argument and I can complete, Milad, within this.
Which one?
Milad, 12, Milad, Rahi, Milad, that Milad, my letter was here
Item
instead
8
of
called. Item 8 called.
Very well, Milad. I know it.
Yes.
Milord, this is my suit. Milord, a suit for recovery of khas position, Milord, as well as for claim for mean profit, etc. Milord, there are 3 IAs, Milord, are pending as on date in your Lordship's board. IA 3 and 4 filed by the defendant. So far as IA 5 is concerned, Milord, that is filed by the plaintiff.
What is the 3?
Milord, so far as IA 3 is concerned, the defendant prays for, Milord, acceptance of the written statement. And so far as IA 4 is concerned, IA 3 is, Milord, somehow in the nature of Order 7, Rule 10. And IA 4 is concerned, Milord, that is for acceptance of the written statement. And the next IA, Milord, that has been filed by the plaintiff is, Milord, in the nature of demurrer, Milord, with some prayers, Milord, that to pay, Milord, the occupation charges, etc. Milord, I believe, Milord, it may be the defendant's turn, Milord, to place, Milord, his case, if any, Milord.
Yes.
With regard to 3 and 4.
3 with regard to the written statement. And 4?
3 is with regard to the order.
So far as IA 5 is concerned, that is my application. Milord, we are, Milord, filing the reply. Milord, may it be accepted, Milord.
Yes.
Milord, a copy is also being served to them.
So 3 with regard to demurrer.
The maintainability application. Order 7, Rule 11, and there's an alternative prayer for return of plaint.
Yes.
Order 7, Rule 10.
Okay.
This is the application that was being moved.
Yes.
So far as GA number 4 is concerned, for leave to file written statement, the application was also filed within the period, and written statement has been affirmed. But it was kept pending because this maintainability application was being heard. And GA number 5, which is my learned friend's application for special officer and
GA3
deposit of the arrear rent.
Yes.
They are enjoying an interim order. I have been directed to make payment at the last paid rent together with periodical increments. I am paying that from time to time.
Yes.
Now, if your Lordship permits, I wish to move my application.
Which one?
IAGA number 3.
Yes.
Which is the rejection and or return of plaint.
Yes.
The application is really premised on the ground that it is not a commercial dispute.
Okay.
The subject matter of the suit is for recovery of possession and arrears of rent. There is no agreement between the parties, and even the notice to quit issued under 106 was for termination of the monthly tenancy. Now, the T. Thompson judgment has now come in. When I was moving this, that was not there. In fact, it's ironic that there were a series of your Lordship's judgments where your Lordship had followed the Deepak Polyama view, and I had placed those decisions before Justice Mukherjee. That apart, today, the first task that I am faced with is to overcome the T. Thompson. I'll try to persuade your Lordship that T. Thompson perhaps does not apply in the facts of our case, because your Lordship knows far better that in that matter, there were 2 registered deeds of lease. They were registered deeds. So the question of validity of those lease agreements was never in doubt. And in fact, the questions which your Lordship referred to the division bench was also premised that there were valid agreements and they had expired by efflux of time. So the question really was whether the court could look into those documents. I'll place the T. Thompson. And the division bench held that even in a 106 situation, even though the termination of use of the monthly tenancy,
the court can always look into that document to determine the jural relationship between the parties. And to ascertain what is the nature and purpose of the lease, whether it was for manufacturing activity or non-manufacturing, based on which the period.
That is the conditions.
Exactly. Now, ours is materially different on the fact, so far as the lease agreement existence is concerned. The narrative of facts in the plaint, I will go strictly by the plaint, as also the 106 notice, which is part of the plaint. They narrate that there was such a lease agreement executed between the parties. It was an agreement for 21 years. But very consciously, they have given a go-by to that agreement because it is an unregistered, unstamped document. And your lordship knows all too well that an unregistered, unstamped document cannot be looked into for any purpose other than the recognized exceptions. So even the language of 106 opens with unless there is a contract to the contrary. And even that has been held by a series of decisions that a contract has to imply the existence of a valid contract. And an unregistered, unstamped document cannot be treated as a contract to the contrary within the meaning of 106.
You are the tenant.
Yes, I'm the tenant.
You are you are possessing the tenanted premises.
Yes, madam.
What you are doing? You are
running a school.
Purpose.
It's a school. It's a kindergarten and primary school. Also an admitted position.
Private school.
Private school. Private school aided. It is aided.
What would happen? What
Yes,
would happen if it is a private school running the business?
Yes, madam.
And you are using the premises for the exclusive for the business? Then what will happen? Leave aside the mercantile document.
Well, that would be my second limb of argument. I'll come to that. Whether running an educational institution qualifies as trade or commerce within the meaning of the Commercial Courts Act. That is my second argument, not as strong as the first one. I will come to that also. That even assuming for the sake of argument that your lordship is not with me on the first issue, that this is not a dispute which arises out of an agreement, even then, it is not a case where an immovable property is used exclusively for trade or commerce because it is an educational institution. Well, I'm relying on certain Supreme Courts, I'll place those. But for so far as the facts are concerned, may I first just show your lordship the case made out in the plaint. Well, the first, your lordship will find the plaint at running page 13 of my application.
Yes.
First, your lordship sees paragraph 7, which is at running page 16, internal page 7. As this is so far as the second argument is concerned, the nature of use. I'm placing very quickly amongst various terms and conditions of the tenancy as more fully reduced in the tenancy agreement dated 1st May 2001. It was also preconditioned that the tenanted premises, i.e. the suit property, shall be used by the defendant for school purpose only. Thus, the defendant has been in possession and or occupation of the suit property and has also used and exploited it for commercial purposes since May 1, 2001. So, admitted position in the plaint is that it was given out for running a school. Now, my lord, kindly comes to paragraph 26. Internal page 13.
Yes.
This is where they refer to the 106 notice. And I'll show you the notice also. As such, plaintiff is sought to determine and or terminate the said tenancy of the defendant in respect to the suit property and therefore has caused a notice to be issued on February 2nd, 2021 under section 106 of the Transfer Property Act 1882. Plaintiff is also called upon the defendant to quit vacate, deliver up peaceful and vacant possession of the suit property upon expiry of 15 days. So they treat it as a monthly tenancy. Now, your lordship kindly sees the 106 notice at page 74. I'm sorry, it starts at 72. The relevant portion is at page 74, first paragraph, your lordship kindly takes.
Yes.
The first paragraph and the third paragraph, categorical stand of the plaintiff is that it is a monthly tenancy.
Yes.
Your tenancy to the said property, including your liability to pay service charges thereof, is from month to month and terminable at any time. Rent, service charges, and other dues shall remain unpaid for 3 months. After the same shall have become due and payable, and thus governed by the provisions of the Transfer Property Act. Then the third paragraph kindly takes on that page. Our client is no longer interested in continuing with your monthly tenancy. And succinctly, we on behalf of our client do hereby give you this notice that your monthly tenancy with regard to the said property stands determined and or terminated upon expiry of 15 days. So clear case made out in the plaint, consistent with the 106 notice, that it is a case of monthly tenancy which they have terminated by issuing the 106 notice.
Yes.
Now, my lord, your lordship will first take up the T. Thompson decision. Now, before that, my lord, may I just show your lordship that the agreement. Also, my lord, there is no dispute that it is an unregistered, unstamped document.
They are not relying
on a 10 rupee stamp paper.
They are not relying on.
Yes, they have relied on it in the plaint, my lord. It is also annexed to the plaint. Page 38 of my application kindly says. This is the agreement. Admittedly, unregistered, unstamped.
Yes.
And also, my lord, significantly, there is a termination clause. The termination clause, your lordship will find at page 43. Towards the bottom, my lord, is it legible? Because my copy is not very.
If the tenants are not.
Clause 11, my lord.
Yes, 11.
Below that, yes, my lord. Provided always. Provided always, and it is hereby agreed and declared by and between the parties hereto that if at any time the monthly rent, municipal rates and taxes and service charge and other so and so shall remain unpaid for 3 months after the same shall have become due and payable, whether demanded or not, or if there shall be any breach or non-observance or non-performance of the terms, conditions, covenants, conditions herein contained and on the part of the tenant to be observed, then the landlord stroke manager shall have the right to determine this tenancy and shall have also the right to re-enter into the said tenanted premises, demise premises, and the landlord manager shall also have the right to adjust the said monthly rent, municipal rates and taxes and service charges and other monies, if any, from and out of the aforesaid security deposit and refund the balance thereof to the tenant. So, my lord, what comes from this is that there is no period prescribed. So it is immediate. The landlord under this document has a right to forthwith enter upon possession and take, my lord, vacant possession of the property. So not even a requirement for 15 days notice, which, my lord, if your lordship compares with the 106 notice, my lord, there's a categorical departure. They do not rely upon this agreement. What they do is they treat it as a monthly tenancy and they terminate that. Now your lordship kindly takes up the T. Thompson decision. Well, just a few paragraphs I will, my lord, place, my lord, to distinguish this from our case.
Yes.
First, your lordship will just take the questions, my lord, which were formulated right at the top. The first paragraph. Copy acha? 2025 SCC online. 2025 SCC online, Calcutta, 5076. Your lordship has, my lord, found ABC, the 3 questions that were formulated in the reference.
Yes.
One is whether issuance of notice under 106. After issuance of the notice, the defendant or parties cannot rely on the agreement or lease deed as the case may be.
Correct.
Second is whether only on the basis of the case initiated under 106, it can be said that the court cannot look into the agreement between the parties and thus the suit cannot be treated as commercial suit in terms of 2-1.
Yes.
And the third was whether the explanation, whether if the explanation under 2-1C of the Commercial Courts Act is taken into consideration along with 106, the suit can be treated as a commercial suit in terms of the lease agreement, rent agreement entered into between the parties. So, my lord, all 3 questions, my lord, proceed on the premise, and I'll show your lordship, my lord, the short narrative of facts because the division bench has not really gone into, my lord, the depths of the fact because that was not an issue. My lord, that there was a valid written agreement between the parties which expired by efflux of time. Now, your lordship comes straight away to paragraph 18 of this judgment. Well, this is part of the submission of the plaintiff, Mr. Thakkar's submission. While dealing, well, your lordship has found paragraph 80. While dealing with a suit filed after issuance of a notice issued under 106, the court has to look into the contract between the parties, as the provisions of 106 relating to tenure and termination of the lease apply only subject to contract between the parties. Therefore, the contract between the parties has to be looked into, and if it is a contract relating to immovable property used exclusively in trade or commerce, any dispute arising therefrom would be a commercial dispute. So this was, my lord, the contention before your lordship as also before the division bench. Now, my lord, kindly comes to paragraph 22. Well, this is the contention of the defendant. Apropos, my lord, the contention of the plaintiff. Kindly see paragraph 22, Mr. So-and-so, appearing on behalf of the defendants, has submitted that in order to determine the issue, it is essential to understand the case of the plaintiff as stated in the plaint. It is submitted that the plaint refers to two registered deeds of lease, both dated 31st January 1969. Both of them claimed to have expired on 31st January 1990 and 28th February 1990. Thereafter, the plaintiff treated the lease as a monthly lease and determined the same by a common notice dated so-and-so issued under 106. Defendants did not comply with the said notice, hence the suit was filed for eviction and other consequential reliefs.
Yes.
Now, my lord, paragraph 37, my lord, which is continuation of the submissions of the defendant, my lord, towards the last 6 lines, in view thereof. Paragraph 37.
Yes.
In view thereof,
Yes.
it is submitted that there is no requirement to look into any agreement or lease deed. The only requirement in law would be to prove valid notice and service of such notice in action under section 106 after expiry of the lease by efflux of time. So, my lord, the real, my lord, question in issue was whether the court is required to look into an agreement which is, my lord, which proceeds on the premise that there is a valid agreement. Now, my lord, the findings your lordship will find, my lord, start at paragraph 67. Your lordship comes straight away to paragraph 78.
Yes.
Well, from 78 refers to the Delhi decision. Well, it comes to 84.
Yes.
Under section 107, well, your lordship found. Under section 107 of the Act, parties have an option to enter into a lease in respect of an immovable property, either for a term less than a year or from year to year, for any term exceeding 1 year or reserving a yearly rent. If they decide upon having a lease in respect of any immovable property from year to year, or for any term exceeding 1 year or reserving a yearly rent, such a lease has to be executed by a registered instrument. In the absence of a registered instrument, lordship kindly marks this portion because the division bench has relied on, well, at Park Street Properties, well, at KC took all those decisions. In the absence of a registered instrument, no valid lease from year to year or for a term exceeding 1 year or reserving a yearly rent can be created. If the lease is not a valid lease, within the meaning of the opening words of section 106, the rule of construction embodied therein would not be attracted.
Correct. Yes.
So, my lord, even to attract 106, my lord, there has to be a valid agreement between the parties, which, my lord, the court says, if there is such a valid agreement,
yes,
the suit court can look into that agreement for the purpose of determining these issues.
Yes.
So the entire thing, my lord, is based on the existence of a valid agreement.
Correct.
Now, my lord, page 87, your lordship will see, my lord, the division bench has referred to the Park Street Properties decision.
Yes.
The decision, your lordship has found 87. The decision in Park Street Properties is an authority for the proposition that the document, which is required to be registered if unregistered, is not admissible in evidence under section 49. In absence of a registered instrument, no valid lease from year to year or for a term exceeding 1 year or reserving a yearly rent could be created. However, dehors the instrument, parties can create a lease envisaged in the second paragraph of 107. It is observed in paragraph so and so that section 106 creates a deemed monthly tenancy in those cases where there is no express contract to the contrary, which is terminable at a notice period of 15 days. In the absence of a registered instrument, the courts are not precluded from determining the factum of tenancy from other evidence on record as well as conduct of parties. It is only when there is a valid lease agreement then can the court look into that document to determine these issues.
Correct.
Which in our case, my lord, in my respectful submission,
No.
cannot under any circumstances be other evidence, because that document cannot be treated as evidence.
Correct.
While section 106 does contain the phrase in the absence of a contract to the contrary, it is well settled position of law that the same must be a valid contract. As an unregistered lease deed for a period of more than 1 year is not a valid lease within the meaning of the open words of 106 TPA, the rule of construction embodied therein would not be attractive. Thus, in the absence of a registration of such a document, what is deemed to be created is a month-to-month tenancy, the termination of which is governed by 106. Then, my lord, 89, my lord, KC 2 is, my lord, quoted. Then your lordship kindly comes to 91, my lord, right after the quoted portion.
Yes.
The aforesaid paragraph, my lord, I'm not placing, my lord, the two quoted portion on this. The aforesaid paragraph makes it clear that the contract between the parties has to be a valid contract, which is only possible if the contract is placed and considered in the said proceeding. But in our case, again, at the cost of repetition, it is not a case where the document can be placed or considered by the court. To summarize, a bare reading of 106 of the transfer of property, 92 I'm placing, will clearly indicate that the reference has to be made to the lease agreement itself for determining the purpose of the lease. If it is for agricultural or manufacturing purpose, then it will be for a lease from year to year. And if not, and for any other purpose, it will be a lease deemed to be from month to month. The period of notice terminating the lease will depend on the purpose for which the lease has been given. Thus, reference to agreement of lease cannot be avoided. All of this premise that it should be a valid lease agreement. And just a few more paragraphs. Paragraphs 96. The submission of the learned amicus curiae is recorded. What are the two-pronged tests required to be taken into consideration in a 106 situation? One, your lordship has found 96.
Yes.
One is whether there is a jural relationship of the landlord and tenant. This involves reference to agreement of tenancy express or implied.
Yes.
And two, if so, whether the notice of termination of jural relationship of the landlord and tenant is valid. It is only for the purposes of one that the court may be required to look into the lease agreement. But again, provided it is a valid agreement. Now kindly sees paragraph 99. So this is really the concluding portion. But from 98, if your lordship kindly takes.
Yes.
Thus, a suit involving termination of tenancy by notice under 106 would primarily involve determination of existence of jural relationship of landlord and tenant by reference to the lease agreement, express or implied. Termination of tenancy under 106 is not the only question for consideration of the court in a suit for recovery of possession where tenancy has been determined by 15 days notice. Notice of termination of tenancy under 106 for termination of lease from month to month implies existence of lease agreement. It does not create a right to get recovery of possession. The mode and manner of termination of the agreement of lease or the relief claimed for termination of the agreement is not the criterion to decide the jurisdiction of the commercial court. The only requirement is that the dispute should arise out of the agreement involving an immovable property used exclusively in trade or commerce. Merely the fact that it is a dispute involving immovable property would not be sufficient unless it is used exclusively in trade or commerce. Then 99, a suit is required to be filed after termination of the jural relationship of landlord and tenant, because under the settled law of the land, even a trespasser cannot be evicted without recourse to due process of law. The validity of notice under 106, if raised, will have to be determined by referring to the lease agreement the period of notice is dependent on the nature and character of the lease. The nature of jural relationship between the landlord and tenant will be decided by referring to the lease. So these are the two reasons why the lease agreement may be looked into. And the concluding portion is at page 121, where this is really reiterated. Here also, my lordship kindly takes 121 because 116 is also adverted to.
Yes.
And 116 also proceeds on the premise that there was a valid lease agreement in existence, whereafter the tenant has continued in occupation. In the instant case, as rightly pointed out by learned amicus curiae, the instant suit involves a lease of immovable property by holding over under 116. In this case, there were two separate deeds of lease between the plaintiff and the joint lessees, and the period of such lease expired by flux of time on January 30, 1990 and February 28, 1990. But thereafter, the lessee continued to pay rent and the lessor continuously accepted such rent even after expiry of the lease till December 24, 2010, when the plaintiff suddenly stopped issuing rent receipts, but even thereafter the plaintiff continued to encash the rent checks till March 2011. These facts would appear from the list of dates, from the list of dates and notes of argument submitted by the defendant number 1. The effect of holding over is renewal, kindly marks this, renewal of the original lease from year to year, which again, in my respectful submission, is absent in the facts of our case.
Yes.
Because there cannot be any renewal of a document which
not
has void ab initio. From the very inception, there is no validly executed lease agreement in our case. Or from month to month, according to the purpose for which the property has been leased as laid down in section 116. Since the lease in this case was not granted for manufacturing or agricultural purpose, the lease after termination of the original lease would be a lease from month to month by reason of section 106. We only refer to these facts to show that reference to lease agreement is necessary. And thereafter 122, the reference is answered.
Yes.
So to put it in a nutshell, the T. Thompson decision categorically lays down the two reasons for which the court may be required to look into an agreement. But provided this agreement is
it is the settled law. If the agreement it is more than 1 year, either rent agreement or the lease agreement, it is not registered, it cannot be taken. It is not it is not admissible in evidence. That is already there.
Is
now with regard to the whether the matter this property which you are using or let out, it is a commercial, or that is the only question.
Then I'll come to that. This was more of a argument made because I anticipate my learned friend will heavily rely on T. Thompson, because till before this, the entire argument was centered.
That's why, because
Deepak Polymer.
Because prior to this reference, this court has also had.
There are 4. I was carrying all of them.
So subsequently, when the proviso has been argued before this court, then this court has find that yes, it has not been decided. It is not proper this court to decide this, so then it has been referred to the full bench.
So far as the second argument, will your lordship?
Yes.
Well, I was carrying a few other decisions, although slightly in a different context. I'll place them for formal sake, but I won't cite each and every. I won't read out each and every paragraph. But the first one is, these were in the context of the Arbitration and Conciliation Act, Section 8 applications, whether the subject matter of the arbitration agreement and the subject matter of the suit are one and the same. The reason I was relying on it is the analogy perhaps applies loosely to our case also, because this is a case where the suit has been filed for recovery of possession by termination of a monthly tenancy. It has nothing to do with any written lease, even assuming that there is such a document in existence. I'll just rely on one decision. There is no point multiplying. This is 2020, volume 17 SCC, page 419. '20, volume 7 SCC. 17 SCC, page 419.
Yes. Yes.
This was a case where there were two suits. The earlier suit was decreed on compromise. The later suit was filed alleging breach of and non-compliance with the terms of the compromise decree. The defendant filed a section 8 saying that the original agreement, which was subject matter of the first suit, contained an arbitration agreement. And therefore, the matters which really relate to that dispute should be referred to arbitration. The court said no, because the second suit relates to the compromise decree. And therefore, there is no identity of the cause of action. I'm just relying on paragraph 13
Main the 14
and 14. Yes, Your Lordship has considered this judgment. And the second issue with regard to whether it is a commercial dispute, I'm relying on 1993. Put it down. Yes, yes. 1993, volume 1 SCC, page 645. The Unregistered. Yes, just a few paragraphs. 197 onwards, at page 751.
Yes.
But, I'm reading from after the quoted portion.
Yes.
19(1)(g) is quoted.
Yes.
While we do not wish to express any opinion on the question whether the right to establish an educational institution can be said to be carrying on any occupation within the meaning of 19(1)(g), perhaps it is, we are certainly of the opinion that such activity can neither be a trade or business, nor can it be a profession within the meaning of 19(1)(g). Trade or business normally connotes an activity carried on with a profit motive. Education has never been commerce in this country, making it one is opposed to the ethos, tradition, and sensibilities of this nation. The argument to the contrary has an unholy ring to it. Imparting education has never been treated as trade or business in the country since time immemorial. It has been treated as a religious duty, it has been treated as charitable activity, but never as trade or business. Now, Your Lordship, it kindly comes to 198. Earlier decisions have been referred. We are therefore of the opinion, Your Lordship has found 198. We are therefore of the opinion, adopting the line of reasoning in State of Bombay versus so-and-so, that imparting education cannot be treated as trade or business. Education cannot be allowed to be converted into commerce, nor can the petitioner seek to obtain the said result by relying upon the wider meaning of occupation. The content of the expression occupation has to be ascertained, keeping in mind the fact that clause G employs all four expressions, viz. Profession, occupation, trade, and business. Their fields may overlap, but each of them does certainly have a content of its own, distinct from others. Be that as it may, one thing is clear: imparting of education is not and cannot be allowed to be commerce, cannot be allowed to become commerce. A law existing or future ensuring against it would be a valid measure within the meaning of clause 6 of Article 19. We cannot therefore agree with the contrary proposition enunciated in so and so. Now, my lord, 21C, Your Lordship has seen the language.
Yes.
The language, although this is used in a different context, 19(1)(g), but the language is far wider, as the Supreme Court has said. All four expressions are. I'm sorry, my lord. Keep your.
Yes, yes, yes. You conclude it.
I will.
Any further submission?
Yes, my lord. A little more time I might require.
They don't. Bring the copy next. Counsel for the defendant has argued the matter in connection with GA3 of 2023. Due to paucity of time, hearing could not be completed. Let the matter appear on 19th August.
My lord, before my lord rises, my lord.
Yes. I will take.
No, my lord, I'm not bothering your lordship.
Still on the same foot.
Sorry.
19.
My lord,
Yes.
Item 12, my lord. Second half, my lord, you taking up the company matters.
Correct.
My lord, kindly keeps it any day. I've spoken to Mr. Drolia. He is agreeable, my lord. I'll take 15 minutes and I'll conclude, my lord. Any day, my lord, 11 a.m., my lord, may I take like this? I'll conclude within, my lord, I'll conclude within 11:15. I'll give it to your lordship word.
Enjoy your puja vacation. Celebrate the puja, then come with a fresh mind.
My lord, I am being the shortest, my lord, doing, my lord, this matter, and my lord, I'm doing for the first time. My lord, the plaint was drafted by me, and my lord, I'm concluding it. Any day, 10 minutes. I'll conclude in 10 minutes, my lord.
Let the matter appear on 21st of August under the heading argument at the time.
My lord, my lord is 20. My lord is 21st.
Yes. August.
August. My lord, I was praying for 26th. Is it, my lord, is it a free, my lord? I know, my lord, 26th, my lord, 21st, my lord, now it is, my lord. The difficulty, what should I say to your lordship, my lord? The NCLT has stopped, my lord, online.
26.
26 minutes at the top, I'll conclude on that. 10 minutes. I'll take 10 minutes.
Okay.
My lord, may I only, my lord? My lord, items 15, 16, 17, I'm for the plaintiff undefended suits, my lord, ready for hearing and perhaps decree. My lord, kindly not take it up tomorrow, my lord. I'm in some personal difficulty. Yes, my lord. Kindly push it over to Monday, my lord. Tomorrow I'm in some personal difficulty.
Automatically you have to come on Monday. Because after lunch there is company matters.
Very well, my lord.
Lord, I have a similar prayer, my lord. The next matter, Mr. Mukhopadhyay is there, my
Which
lord.
one?
Lord, the next matter, my lord.
Next
Item
one?
9, my lord. I was only praying, my lord. Tomorrow I have some personal difficulty. If it can appear today, my lord. I'm ready. Otherwise, my lord, I'll take 5 minutes, not more than that.
So ye काम करो 10, 9 and 15, 16, 17 Monday.
Monday. I'm grateful. So grateful, my lord.
Lordship has, in this matter, by an order dated 30th of July, your Lordship has directed one of the joint special officer to be present on 3rd September, your Lordship. On 3rd and 4th, one of the joint special officers is having personal difficulty for some medical reasons, my Lord. That is the only reason. If it can be preponed or postponed, whichever is
Who is the other special officer?
Mrs. Mithua Sen.
Subhajit Roy.
Subhajit Roy. I'm appealing for Mr. Subhajit Roy.
Mithua Sen. Along with special officer Mithua Sen appeared on that day.
On that day.
To talk to her. Talk to her and because both the special officer required to be appeared before.
But that is why I will inform.
So talk to her and come with both. Talk to her. Come with the Mithua Sen. Otherwise, I will not allow.
May I have Lordship's kindly, Lordship, I'm mentioning inclusion of a company petition. Lordship has allowed this on the last week, my Lord. Still, my Lord, it is not appearing. Lordship, may it appear, my Lord. Lordship will kindly direct it to appear next week, my Lord.
They are in search of file.
Logistic.
File is not receivable.
Very well.
Your Lordship, may I have Your Lordship's leave to mention one matter? Your Lordship, this is that matter where the CP number is not available, Your Lordship. We have checked with the office of the official liquidator. They are saying they have not got the records, any records, Your Lordship.
So what can be done?
Your Lordship, we need to file an
If
application.
your CP number is not there, in which you will file the CA?
Your Lordship, the order also does not reflect the CP number, Your Lordship.
So that's why. So what order you record?
Your Lordship, an application needs to be filed because the erstwhile voluntary liquidator who was appointed has passed away without distributing the assets, Your Lordship.
So the liquidator has been passed away. So it might be the record with the official liquidator.
Your Lordship, there's a report that has been filed by the official, that was filed before the official, by the official liquidator, Your Lordship. In that also the CP number is not mentioned, Your Lordship. The order also does not reflect, the report also does not reflect the CP number.
So what you want now?
Your Lordship, we need to file an application and we will not be able to file an application without the number, Your Lordship.
So correct.
Your Lordship.
So in which file your application will go?
Your Lordship.
क्या है कुछ नंबर फिर क्या है? So without the CA number, the CP number, how the application will be entertained?
Your Lordship, I can understand, but
so, and how this court will allow to?
This is the order wherein also, Your Lordship, it is just mentioned in the matter of the name of the company.
This is the only order.
Your Lordship, if a leave may be.
What is the name of the company?
Chemical and Tar Products Private Limited.
This is under liquidation.
Your Lordship,
This
yes.
company is under liquidation.
Your Lordship, a dissolution has been allowed, Your Lordship, by this order, Your Lordship. But the Lordship, the voluntary liquidator has passed away without distribution of the assets, Your Lordship.
So where the money goes?
Your Lordship, the asset has not been distributed. There's only one asset, but it has not been distributed, Your Lordship.
You do one thing. What can be done? You file a miscellaneous application giving all the details. Let me see. You file the details, all these things in a
Grateful, Your Lordship.
Yes, call the list. Yes.
My Lord, I was saying, my Lord, the findings in paragraph 5 of the impugned order.
Yes.
So if your Lordships take, my Lord, the memorandum of appeal, my Lord, paragraph 5. My Lord, I believe your Lordship's taking it up for 1 hour. I was told that's what your Lordship had indicated.
Yes, 1 hour.
Yes. So I'll do the other matters. My Lord, kindly see, my Lord, paragraph 5. My Lord, there were 3, my Lord, findings really. My Lord, which I was, my Lord, challenging. I had placed para 5.
Yes.
My Lord, at page, my Lord, internal page, my Lord, 18. My Lord, right hand bottom, my Lord, other page numbers. My Lord, the 3 findings which I was, my Lord, impugning, my Lord, apropos paragraph 5, are, my Lord, very, very important because, my Lord, they relate to the nature of the company. My Lord, my case was, One, that it's a family company. Second, my lord, equality in shareholding between, my lord, petitioners and respondents.
Correct.
Not, my lord, that we had 50% shareholding by ourselves. And third, my lord, second, my lord, was, my lord, with regard to applicability of principles of partnership. My lord, these were, my lord, the important issues, my lord, which were, my lord, found, my lord, here, that, my lord, since our, my lord, shareholding in the company did not constitute 50% of total shareholding, there was no equality. My lord, this really, my lord, is contrary to even the first sentence, my lord, of, my lord, paragraph 5.
Yes.
That what our case was and what was decided. Second, my lord, was, my lord, our argument that, my lord, being a family company, my lord, partnership principles would apply. My lord, the finding is, my lord, your lordship will find that at page 19, my lord, from third line onwards, respondent company was incorporated in 1950 by taking over the existing business of the partnership firm Glamour Polish, which was a partnership between SC, Purnanand Garg, father of respondent number 2. The father of petitioner number 1 contributed partly towards capital of the firm, and loan given by father of petitioner was subsequently converted to equity. Thus, the original partnership was running Glamour was not set up by joint participation of late father of petitioner number 1 and late father of respondent number 2. Further, father of petitioner number 1 became a director of the company only in so and so while the company was established in 1950. No further evidence has been brought on record by petitioners to justify setting of the company jointly by late father of petitioner number 1 and late father. Therefore, the contentions of petitioners company has been run on quasi having equal sharing between petitioner is not acceptable. So, my lord, quasi partner. Now, my lord, I had, my lord, challenged, my lord, this, my lord, finding. My lord, I had shown your lordship, my lord, from, my lord, the, my lord, annexure A1 of the company petition, my lord, the memorandum and articles of association, my lord, clause 3.1, and, my lord, who were the subscribers. Then, my lord, I had also shown your lordships, my lord, the family tree.
Yes.
My lord, at page 504, to show, my lord, the involvement and participation of father of petitioner number 1 in GPI. Now, my lord, what is important here, my lord, is what were the other factors which would show, my lord, that, my lord, quasi-partnership principle should apply. Now, my lord, the existing partnership firm, my lord, GPI, which was taken over, my lord, kindly now see the involvement, my lord, of the group, my lord, of petitioner number 1 with regard to its setting up and its running, my lord, which have been totally ignored. My lord,
What are the documents you have?
yes, now, my lord, kindly come to, my lord, first, my lord, is para 7 of the rejoinder, which is page 464 of volume 2. 464, para 7. My lord, the patriarch, my lord, was R.K. Garg.
Yes.
Now, my lord, kindly come to, my lord, 464, para 7, my lord, the 5th line. My lord, of para 7, the sentence starting right hand side, I say that, my lord, 4th line, that Harish Chandra Agarwal is the son-in-law of R.K. Garg. Therefore, Mr. Harish Chandra Agarwal is the brother-in-law of both the father of respondent number 2 as well as father of petitioner number 1, a copy of family tree. Then, my lord, the father of petitioner number 1 had given loan to the partnership firm Glamour Polish Industry. Moreover, now kindly note this, the manufacturing facility of Glamour Polish Industries, that's the partnership firm, in 16-1 Lakeview Road was jointly held by both the brothers, Purnanand Garg and Paramanand Garg. So, my lord, father of petitioner number 1 and respondent number 2 had in their, my lord, property, yes, my lord, the, my lord, business was being carried out. In effect, the father of petitioner number 1 was also participating in the partnership business. The fact that my father was substantially interested in GPI is evident from the income tax certificate filed by Parmanand Garg in 1950, a copy of which is annexed and marked B. Now, my lord, kindly have a look at page 506, my lord, volume 2. My lord, 505 and my lord, 506. My lord, 505A, my lord, is my lord, the my lord, yes, my lord, 505A. Lord, kindly see name and style of the company firm in which the applicant is assessed or assessable to income tax and additional purpose for assessment. P. N. Garg, Parmanand Garg. That's my lord, father of petitioner number 1. Then my lord, names and addresses, etc., etc. Kindly come to the bottom. My lord, the signature is also of Parmanand Garg. Lordship has right hand side.
Yes.
Date is 23rd March 1959.
Yes.
And my lord, kindly see, my lord, this is, my lord, this clearly establishes that, my lord, we were, my lord, actively involved, my lord, in GPI.
Yes.
Because, my lord, it's a tax return, my lord, relating to, my lord, the firm,
Yes.
which, my lord, the father of petitioner number 1 is filing. So, my lord, 8 Southern Avenue is, my lord, where both brothers, father of petitioner number 1 and father of respondent number 2, my lord, had, my lord, was their property.
Yes.
My lord, business is being carried on from there, and Parmanand Garg, my lord, is filing the income tax certificate.
Yes.
Then, my lord, kindly come to, my lord, page 52, annexure C of rejoinder, my lord, which is at page, my lord, 507, 7A, volume 2.
Yes. Factory Lakeview Road.
Yes, my lord, kindly have a look at this. This is to certify, my lord, because shares, my lord, were given to father of petitioner number 1 in the year 1985 as consideration for loans advanced by him to GPI. Now, my lord, kindly see, this is to certify the following shares in the company were allotted to Sri Parmanand Garg, so and so, on the date and for consideration noted against. Now, my lord, kindly have a look at, my lord, the typed copy is next page, my lord, 507A, allotted to Sharman on so and so dates, 1951, and my lord, the consideration is, my lord, towards satisfaction of vendors' consideration, my lord, that's number 1, and 51, my lord, the last date, 2000 shares, and so shares paid in payment of its dues from Glamour Polish Industry, which liability to be taken over. So, my lord, then, my lord, kindly come to the land, my lord, where, my lord, this is, my lord, situate. My lord, which I read out to your lordship, my lord, page, paragraph 7, which I read out. Then, my lord, kindly come to, my lord, the sole selling agent of GPI, my lord, that's, my lord, the old partnership firm, my lord, United Commercial Corporation, my lord, was, my lord, the sole selling agent. Now, my lord, not only of partnership firm, but also of respondent number 1. Now, my lord, United Commercial Corporation, my lord, was, my lord, the father of petitioner number 1, my lord, was a partner of United Commercial Corporation along with father of respondent number 2 and H.C. Agarwal. Now, my lord, your lordship will find that at page 681. My lord, entire, my lord, goods. My lord, not only, my lord, first thing. My lord, first is tax returns are being filed, my lord, by father of petitioner number 1. Second, my lord, he's giving loans. My lord, 2, my lord, this partnership firm for it to, my lord, carry on business. Third, my lord, he with his brother and H.C. Agarwal is, my lord, selling, my lord, the entire production of, my lord, GPI and, my lord, the company. Kindly have a look, my lord, at paragraph 12, page, my lord, 680. With reference to para 12, I say that even though the company has had other directors from member, family was always within so and so, so and so. I say there can be no dispute that the family is a family company. Without prejudice to the petitioner's right to challenge the authenticity and reliability of the documents annexed, I say that the same are wholly irrelevant for the purpose of the instant proceedings. My lord, last 5 lines of that page. My grandfather and father of petitioner number 1 and the uncle of respondent number 2 had an active role to play in the affairs of the company. The documents being annexure R9 have been procured at the instance of R2 and do not reflect so and so. The involvement and contribution of my grandfather has been deliberately kept out in such writings. My grandfather was a partner of United Commercial Corporation, which was the sole selling agent for Glamour Polish. A copy of income tax return of PN Garg is annexed here too and marked so and so. Now, my lord, kindly have a look at, my lord, page 769. My lord, the typed copy of, my lord, volume 3.
Yes.
Now, my lord, kindly see 769A, my lord, is the typed copy.
Yes.
My lord, it's assessment year 53, 54. Now, my lord, it appears from the return submitted by you for the above year that you acquired partnership right to United Commercial so in the financial year. Please let me know the date on which you became a partner in the above firm and true copies of your capital account, loan account, suspend account, or account of any other nature and in the books of United during the period. You are also requested to so and so. Please let me know the date of purchase of 5001 ordinary share in Waxpole. Then, my lord, the return is filed. Next page, top, my lord, kindly see.
Yes.
My lord, the heading, form of return of total income and total world income for individuals, Hindu undivided families, companies, local authorities, firm and other association of persons under subsection 1 and 2. My lord, those days it was the 1922 Act, Income Tax Act. Kindly see, my lord. PN Garg, individual, 8 Southern Avenue, Calcutta 26, where the business is, my lord, being carried on. And, my lord, your lordship will find, my lord, 773. My lord,
Yes.
yes, my lord, kindly see the heading, middle of the page, my lord, against, my lord, subpara C, to be completed in cases where the assessee is a partner in a firm of firms. My lord, kindly see name and address of the firm, United Commercial. Name of each partner, H.C. Agarwal, that's the brother-in-law, Parmanand Garg, Purnendu Garg. Both brothers. Father of petitioner number 1 and, my lord, respondent number 2.
Yes.
Now, my lord, these factors, my lord, which were, my lord, important, my lord, have not been considered at all. We were also the guarantor. Get that. Now, my lord, kindly give me a moment. Where is it now? My lord, kindly just give me a moment. Now, my lord, we come to, my lord, the company.
Yes.
Now, my lord, the first extraordinary general meeting of the company, I've shown your lordship the memorandum and articles, my lord, to show our role, my lord, in the company. My lord, 24th November 1950. My lord, the chairman, my lord, of this extraordinary general meeting, my lord, was, my lord, the father of petitioner number 1. Straight after company is formed, page 303. My lord, volume 2. Kindly have a look at volume 2, page 303. My lord, kindly see proceedings of the extraordinary general meeting of the shareholders of Waxport held at the registered office of the company at 8 Southern Avenue on 24th November 1950. Kindly see present H.C. Agarwal, Parmanand Garg. And my lord, after the list of attendees, kindly see, Parmanand Garg was proposed and seconded to be the chairman.
Yes.
Now, my lord, I have already shown your lordships, my lord, that factory premises, my lord, were, my lord, in, my lord, the property, my lord, of, my lord, the father of petitioner number 1 and father of respondent number 2, my lord, in Southern Avenue. Now, my lord, the office land, which was also there, my lord, in Ranchi, was also in their names.
Yes.
Kindly take, my lord, paragraph 7.
Paragraph 7 of?
My lord, this is, my lord, of, my lord, the company petition, which is volume 1, page 89.
Yes.
Where is that one? No, this is.
That is the grounds of the appeal.
Yes, grounds of appeal. My lord, kindly take, my lord. My lord, kindly take, my lord, page, my lord, 266A. My lord, 8 Southern Avenue is mentioned again, my lord, here. My lord, then, my lord, the lordship will find, my lord, apart from that, my lord, the company took over partnership business of Glamour with its factory and was also assigned the name Waxport. Now, my lord, then, my lord, kindly come back to, my lord, page. My lord, page, my lord, 89, my lord, where I had drawn your lordship's, my lord, attention to. My lord, that is, my lord, volume 1 of the appeal paper book. It's the petition, my lord, it's not the grounds. Para 7. Both brothers jointly owned land in plot measuring 10 acres in Purulia Road.
Page 89.
Page 89. My lord.
That is a ground.
No, your lordship's looking at the memorandum of appeal. My lord, kindly take.
Volume 1. Volume 1.
My lord, a
Okay,
paper
yes,
book,
yes,
my
yes.
lord. I'm sorry, my lord.
Sorry.
Full valve also.
Yes.
My lord, kindly see para 7. Both brothers jointly owned land in plot measuring 10 acres in Purulia. The said plot was transferred to the company and the present factory was the present branch office of the company at Ranchi at Kanke Road was jointly owned by brothers and transferred to the company in 1990. Company is a family company wherein equal percentage. And my lord, kindly have a look at para 8. My lord, the company was not the only commercial venture taken jointly by the two families. There were other companies, namely Tagopan Chemicals, Neo Chemicals, and Metal, which were jointly owned by the two families. Moreover, petitioner number 1, respondent number 2 were in partnership so and so. All these so and so, and my lord, at all times the two families lived together at Garg Nivas, Ranchi.
Yes.
And my lord, kindly have a look at page 871. What do I? Volume 4. Enter it in the notes. My lord, this is, my lord, Waxpole Industry meeting. Kindly see where it's happening. Lake Avenue, Kanke Road, Ranchi, where, my lord, both brothers, my lord, are there. Purnanand Garg and Parmanand Garg, father of petitioner number 1 and, my lord, father of respondent number 2. My lord, this is, my lord, in 1980 also. Now, my lord, kindly take, my lord, page 512, 515 of, my lord, Rejoinder, volume 2. My lord, this is, my lord, from the Rejoinder. My lord, it's part of, my lord, the paper book. The paper book, my lord. My lord, 512 to 515.
Yes. These are bills.
Yes, my lord, these show, my lord, 514 will make it clear. Please find enclosed herewith 2 letters bearing so and so, both rated 9, addressed to Kusum Garg and Parmanand Garg, respectively, along with 3 demand draft, being interest payment for quarter ending towards deposits made by them. So, my lord, finances, my lord, were also being provided, my lord, by, my lord, Parmanand Garg.
Yes.
And 516, your lordship will find, my lord, retainer fees, my lord, remuneration, my lord, is also being paid, my lord, to, my lord, father of, my lord, petitioner number 1.
Yes.
Then, my lord, most important, my lord, father of petitioner number 1, my lord, if he was nobody in the company, gave the personal guarantee, my lord, for loans. Kindly have a look, which has been totally ignored. These were all on record. My lord, what were we showing? What was our endeavor? My lord, first was that it was a family company. Why do we say family company? Because the total shareholding of the Gargs, my lord, were over 50%.
Yes.
So, my lord, the family, my lord, could control. My lord, therefore, it's a family company. That is the test. Secondly, my lord, partnership principles were applicable here because the shareholding between the 2 branches of the Gargs had, my lord, more or less equal shares. I'm not saying they were exactly equal, more or less equal shares. And, my lord, the finding doesn't record that. Finding says you don't have more than, you don't have 50, which is a wrong test. But the shareholding they've given, my lord, is, my lord, showing that, my lord, we have, my lord, equality in shares. Then they say partnership principle cannot apply because you weren't involved in the original partnership which was taken over. My lord, first is, that's, my lord, being applied as the sole test is wrong. Because, my lord, the first test is you look at the articles, you look at the shareholding, and is it a family company or not? If it is, then, my lord, the partnership principles will anyway apply. Secondly, my lord, in any view of the matter, if you want to see whether, if you say the test is dependent on whether a pre-existing partnership was taken over, the answer is yes. Then they say, well, you want a party to that partnership. But then, my lord, one has to look at, my lord, the business realities. But now, my lord, more importantly, with the company, I am nobody. Now, kindly have a look, my lord, at, my lord, my lord, at page 468, first I want to show, my lord. My lord, page 468, it is part of the rejoinder, my lord, in the company petition. Kindly see. The father of the petitioner number 1, your lordship has that, my lord, had given personal guarantee to the bank for credit facilities enjoyed by the company. Such personal guarantee was subsequently released by secured creditor. A copy of the letter dated 11th November 1986 issued by United Bank is annexed here too. The respondents have deliberately fished out one document being annexure 4 to substantiate, if possible, that unfounded allegation that father was not involved in active marriage. I am giving the guarantee. Bank is recognizing me that you are the person who should give the guarantee.
Okay.
Now, my lord, the guarantee, now kindly have a look. My lord, kindly take, my lord, page 519, same volume, my lord. My lord, in 1956, Now it should be 1986 actually. My lord, it's 86, 519, your lordship will find the original, my lord.
86.
It's 86, my lord, is when, my lord, it is released.
Yes.
Then, my lord, the father of the petitioner number one was the single largest shareholder of the company till, my lord, the illegal rejection. My lord, your lordship recalls, my lord, the 99 issue or 95 issue. What was it?
Yes.
95 issue, which is the first issue of shares. My lord, where, my lord, because we didn't give a PAN card, my lord, and there was joint application, my lord, it was rejected by them. My lord, kindly see page, my lord, 466 of, my lord, the paper book, my lord, in the same volume, my lord, volume 2,
Yes.
my lord, middle of the page, I say that father of petitioner number one was issued and allotted so and so on 20. Such issue and allotment will appear from. In fact, the father of the petitioner number, I've shown these documents. In fact, father of petitioner number one was the single largest shareholder in Waxpol, holding so and so in his own name till illegal. He's also extended unsecured loans, etc. And my lord, not only that, father of petitioner number one also, my lord, chaired board meetings, which I've shown your lordship, my lord, at page 875 in, my lord, Kanke Road. Now, my lord, an amazing thing here. My lord, father of petitioner number one and father of respondent number two. My lord, this is very, very important because the company, my lord, is set up on the basis of personal relationship.
Yes.
My lord, they were brothers, own brothers. Now, my lord, mother of petitioner number one and, my lord, mother of respondent number two are sisters, own sisters. My lord, one can't get closer. Second, my lord, both these families live together, my lord, in the joint property called Garg Nivas in, my lord, Ranchi.
That is given.
Yes. And, my lord, board meetings were also here. And, my lord, they had equal holding in other business ventures as well. So, my lord, now, my lord, P1 and, my lord, R2 being first cousins, they joined the company together and were appointed as directors at the same time. My lord, these are important facts. My lord, father of petitioner number one, respondent number two, my lord, first shareholders, therefore first directors. That's the law. Then, my lord, comes, my lord, the sons. My lord, they join the company at the same time. They, my lord, become directors also at the same time.
So whether these documents were produced before?
Everything. Everything, my lord, all that your lordship has, my lord, are the records, my lord, which were before, my lord, the company law board. And I'll show your lordship one thing. The notes that were filed by us refer to all these documents. All of them.
Yes.
Now, my lord, petitioner number one, kindly see his involvement. My lord, he is given charge and control of the factories of the company and was responsible for managing them. And, my lord, he was given a letter of appreciation, my lord, for rendering 25 years of service. Now, my lord, first thing, my lord, kindly take 476. My lord, 475 rather, paragraph 11.
Yes.
My lord, kindly see. Kindly give me 1 minute. My lord, may I read para 11 at 475? With reference to paras 15 and 16 of the affidavit, I repeat the statements made in so and so and deny. I say that myself and respondent number 2 were appointed as management trainee in the same year and were elevated on the board on 21st November 86 on the same date. Well, they were 19 years of age when both of them got inducted into the company as management trainee in the ranks. Then they were, my lord, appointed directors, my lord, in November 96. I say that the arrangement between the family members was such that I was given the responsibility of looking after the business of its two important factories at Tatsevai and Butti. The Raipur and Chennai factories are small considering other two factories which are main factories. I was an overall management of other two factories also, and such fact will appear from a board resolution dated 14 March, extract of which was forwarded to me by a letter dated so and so, etc. And my lord, now my lord, kindly come to my lord that letter. My lord, page 534, my lord, volume 3. My lord, 23rd March. We are reproducing below the extract of the resolution passed by the Board of Directors at their meeting held on 14 March 2001 for your kind information and necessary action. Resolved that in supersession of all earlier resolutions, Rajiv Garg, Director, be and is hereby in charge and responsible for the conduct of the business of the company in all matters as appended below. Then, my lord, overall supervision of management and control of company's works at so-and-so and Bhutti by proper coordination, modernization and expansion of the works by additional constructions and installation of plant and machinery, to submit a report on his activities to the Board of Directors, of kindly acknowledged by signing. My lord, and my lord, we are being told that, my lord, who are you? You were not involved at all. You were sitting outside. You now, my lord, kindly come to, my lord, page 544A. My lord, this is, my lord, 26.
Yes.
The management wishes to place on record, place on continuous appreciation for the dedicated and devoted service rendered by you for the continuous period of 25 years. Recognition of the same, management is pleased to reward you in cash with a draft of 34,000 so and so. It is expected that you will continue with the same so and so. You will do all. Yours truly, Waxpole R.P. Gupta. My lord, those days your lordships would recall there was a cap on director ceilings. My lord, many persons, my lord, before, my lord, that end of tenure, my lord, as a director, would, my lord, resign and take up, my lord, an executive post where much more could be paid, so that, my lord, pensionary benefits, my lord, would be higher during, my lord, their retirement. Here, my lord, again, as, my lord, appreciation, my lord, an award is being given. Now, my lord, even after the 1995 allotment, and this is our case, my lord, which is, my lord, page, my lord, 569, my lord, of volume 3, 564 to, my lord, 569, my lord, we had filed a supplementary affidavit.
Yes.
My lord, kindly come to, my lord, paragraph 2. I say that the petitioners, your lordship, my lord, 563 it starts, my lord, para 2.
Yes.
I say that the petitioners had in the main petition filed in these proceedings referred to Company Secretary Vinod Kothari and Company being appointed for the purpose of exploring the possibility of dividing the assets of the company between the two branches, petitioners and respondents. At the time of filing of pleadings in the proceeding, original of such reference letter as well as its copy could not be traced. The petitioners have subsequently found the original of the note dated 13 January 98, a copy. The note refers to a note prepared by Vinod Kothari laying down the procedure for splitting up the company, and such note has been duly forwarded to the father of respondent number 2. By the note dated 13 January, petitioner number 1 was called upon to specify the point of reference. Petitioner number 1 had informed the point of reference both to the father of respondent number 2 as well as the company secretary. Discussions took place for splitting of company on basis of 50-50 partnership. Various options, however, no steps. Pursuant to filing, I had caused inquiries to be made with superintendents in respect of alleged dispatch. My lord, that's a separate issue. My lord, now kindly see, my lord, the note. My lord, memorandum to Rajiv Garg, from head office Calcutta. Mr. P.N. Garg, chairman, received a copy of note prepared by Vinod Kotari. And kindly see the date, my lord. This is 13 January 1988. And my lord, the signatory, my lord, is R.P. Gupta, who had given me the certificate as my lord a director. Now, my lord, company laying down the procedure for splitting up our company. In this connection, it desires to know from you point of reference based on which the said note has been prepared. Kindly, therefore, write to him the details.
Yes.
My lord, this is the note. My lord, even my lord, after my lord, the my lord 95 issue and allotment, my lord, this is my lord what had happened. Now, my lord, the company, my lord, is a public limited company, but my lord, kindly sees the restriction, my lord, which was maintained, my lord, in the articles. My lord, kindly see page 182, capital A, clause 39A. The directors, I'm sorry, my lord, without assigning any reason for such refusal, may decline to register any transfer of shares to a transferee of whom they do not approve, or decline to register the transfer on which the company has a lien subject to right. So, my lord, they retained absolute discretion because, my lord, it was a closely held company. It was a family company. So, my lord, if an outsider was to come in, my lord, their board needed to approve. And my lord, both my lord groups, my lord, had representation, my lord, on the board. Now, my lord, here, my lord, I just wish to, my lord, rely on, my lord, a few cases. My lord, the first case, my lord, I wish to rely on, my lord, is my lord Ibrahimi's case. My lord, that's my lord 1972 to All England Report 492. What are the paras? My lord, I believe, my lord, your lordship's been favored with, my lord, the weekly law reports rather than, my lord, the appeal cases or, my lord, the, my lord, All England reports. So, my lord, it is 1972, two weekly law reports, 1289.
Yes.
My lord, the first and most important, my lord, aspect of this case, my lord, I'll tell your lordships, my lord, the fact here, my lord, Ibrahimi's, my lord, was, my lord, a case of, my lord, um, winding up on just and equitable grounds. Now, my lord, in England, my lord, the relevant section at that point of time was section 210, which was akin, my lord, to our section 397. So it was recognized, my lord, that it is an alternative to winding up, 397. Now, my lord, kindly come to, my lord, Lord Wilberforce's, my lord, my lord, 496. My lord, kindly come to my lord, kindly give me a moment. I'll just. Yes. My lord, kindly see 495. My lord, I'm sorry, my lord. 1293. My lord, your lordships, my lord. 1293.
Yes.
My lord, kindly see. This petition was based in the first place. Lordship has that, my lord. On section 210 of the Companies Act 1948, the relief sought under this section being an order that Mr. Nazar and his son be ordered to purchase the appellant shares in the company. In the alternative, it sought an order of winding up. Petition contained allegations of oppression, mismanagement, found that some were unfounded and others unproved, was made, but however, they made an order for winding up on just and equitable grounds. Now, my lord, kindly come to my lord, the the portion starting Placidum H, one other signpost
Yes.
is significant. The same words, just and equitable, appear in the Partnership Act.
Section 20.
The Lordship has that, my lord, under section so and so as a ground for dissolution, and no doubt the considerations which they reflect form part of the common law of partnership before it's. The importance of this is to provide a bridge between cases under section 222F of the Companies Act and the principles of equity developed in relation to partnership. Now, my lord, 222F is, my lord, a winding up provision, my lord, similar to, my lord, our earlier 433F, my lord, on just and equitable grounds. Now, my lord, the winding up order was made following a doctrine which has developed in the court since the beginning of the century, as represented by the appellant and in substance accepted by the learned judge. This was a case such as this. The members of the company are in substance, kindly note, partners or quasi-partners, and that a winding up may be ordered if such facts are shown as could justify a dissolution. Now, my lord, kindly go down a few lines. Then, my lord, it says the main line of his submission. My lord, at page 1294, my lord.
Yes, 1294. Same paragraph.
Yes, my lord. My lord, kindly see Placidum B.
Yes, the main, yes.
Lordship has that, my lord?
Yes.
The main line of his submission.
Suggest.
Yes, my lord, I have lost it with my. The main line of his submission was to suggest that too great a use of the partnership analogy had been made, that a limited company, however small, essentially differs from a partnership, that in the case of a company, the rights of its members are governed by the articles which have contractual force, that the court has no power or at least not to dispense parties from observing the contracts, that in particular, when one member has been excluded from the directorate or management under powers expressly conferred by Companies Act and the articles, an order for winding up, whether on partnership analogy or under the just and equitable provision, should not be made. Alternatively, it was so and so. Now, my lord, after all this, this was the argument that, look, company and partnership you cannot equate. So if in accordance with the articles and the act, somebody is being thrown out, somebody is being sidelined, nobody should complain. Now, my lord, kindly, my lord, turn over the page. At page 1295. Lordship has that, my lord, 1295.
Yes.
My lord, Placidum C in 1924.
Yes.
Lordship has that, my lord?
Yes.
Now, my lord, may I read from here? In 1924, these authorities were reviewed, approved, and extended overseas by the Judicial Committee of the Privy Council in an appeal from the West Indian Court of Appeal, Locke versus John Blackwood. Now, my lord, I pause here. This is a decision which has been accepted by our high courts, which says even if a company is a public company and listed, it can still be a family company if the preponderance of voting power is with a family. Now, my lord, kindly see this. The judgment of the board delivered by Lord Shaw of Dunfermline clearly endorses, if not enlarges, the width to be given to the just and equitable clause. The case itself was, kindly note this, one of a domestic company and was not one of deadlock. One of the directors had given grounds for loss of confidence in his probity, and a matter echoed in the present case had shown that he regarded the business as his own. His lordship quotes with approval. And then, my lord, I note in passing the Scottish case of Thompson and Drysdale, when a winding up was ordered under just and equitable clause at the instance of a holder of only one share against the only other shareholder who held 1501 shares. Clearly not a case of it. So even, my lord, all that it is saying, that, my lord, just an equitable test can be satisfied even if there is no equality of shareholding. If the nature of the company is such that, my lord, personal relation. Now, my lord, kindly come to, my lord, three cases are mentioned. Then, my lord, after discussing, my lord, all these cases, My lord, ultimately, my lords, in my opinion, my lord, 1297.
Yes.
After discussing all these cases, my lord, the portion starting, my lord, with my lords.
Yes.
My lords, in my opinion, these authorities represent a sound and rational development of the law, which should be endorsed. The foundation of it lies in the word just and equitable. And if there is in any respect in which some of the cases may be open to criticism, now kindly note this. It is that the courts may sometimes have been too timorous in giving them full force. My lord, they've been conservative. Now, my lord, the words are a recognition of the fact. Now, this is, my lord, most important. That a limited company is more than a mere judicial entity with a personality in law of its own. That there is room in company law for recognition of the fact that behind it or amongst it, there are individuals with rights, expectations, and obligations inter se, which are not necessarily submerged in the company structure. So, my lord, one needs to look at the business reality.
Yes.
How was the company set up? Because, my lord, rights, expectations, obligations, my lord, are not, my lord, solely to be found in the Act or, my lord, articles. Now, kindly, the structure is defined by the Companies Act and by the Articles of Association by which shareholders agree to be bound. In most companies and in most contexts, this definition is sufficient and exhaustive equally, so that whether the company is large or small, the just and equitable provision does not, as the respondent suggests, entitle one party to disregard the obligation he assumes by entering a company, nor the court to dispense him from it. It does, kindly note this, as equities always does, enable the court to subject the exercise of legal rights to equitable considerations. So, my lord, whenever, my lord, I say, oh, I'm right, you are a minority, I can throw you out. So, I remove you. But, my lord, if, my lord, the nature of the company is such that it's a family company, or, my lord, it is, my lord, has restrictions, closely held company, my lord, the courts might say, no, your exercise of legal right will have to be examined under equitable consideration. Now, kindly see the next. Considerations that is of a personal character arising between one individual and another, which may make it unjust or inequitable to insist on legal rights or to exercise them in a particular way. It would be impossible and wholly undesirable to define the circumstances in which these considerations may arise. Certainly, the fact that a company is a small one or a private company is not enough. There are very many of these where the association is a purely commercial one, of which it can be safely said that the basis of association is adequately and exhaustively laid down in the articles. The superimposition of equitable consideration requires something more, which typically may include one or probably more of the following elements. An association formed or continued on the basis of personal relationship involving mutual confidence, the element will often be found where a pre-existing partnership has been converted into a limited company. So, my lord, if it's based on personal relationship, and my lord, if it was, my lord, just the family, that itself is good enough. Second, my lord, test is, if, my lord, it's based on personal relationship, the foundation of which is trust and confidence, like a partnership, my lord, again, my lord, it would apply. Then, my lord, kindly see 2, an agreement or understanding that all or some, for there may be sleeping members of the shareholders, shall participate in the conduct of the business. The restriction on the transfer of members' interest in the company, so that if its confidence is lost or one member is removed, he cannot take out his stake and go elsewhere. So that it remains closely held. It is these and analogous factors which may bring into force, etc. Then, my lord, kindly come to. Then, my lord, the facts, my lord, and my lord, equal share, etc. is, my lord, from, my lord, I come, that paragraph starting, I come to the facts of the case at page 1298. One two nine nine. I'm sorry, my lord. 1299. Third line. And my lord, here, in effect, my lord, it's expulsion. My lord, take away directorship, take away shareholding. 95, 2000 and 2009 and 2011. So steadily, my lord, take, my lord, my lord, one branch of the family, my lord, completely, my lord, outside. Now, my lord, this, my lord, case, my lord, has received, my lord.
So what is the situation today?
My lord, they are in total control.
In control, they're receiving dividends for the last.
Yes, of course, I am entitled to. My lord, I am supposed to get, my lord, I am supposed to get 25,000. But if I get 7,000, I'm not going to say no. It's very simple. That's the argument which has appealed. That, oh, you've been receiving dividends. What does that mean? If I'm getting more than what I'm entitled to, it's something else. But if I'm getting less, it is meaningless. It shows continued oppression.
Yes.
My lord, these, my lord, little tricks, my lord, which work, my lord, in the minds of, my lord, the tribunals, my lord, should not be working in the High Court.
No, I don't think, Mullah, that's the point. Don't say that. That's not.
Now, my lord, kindly.
When we make our
Yes, yes, of course.
what rights they have and what the rights they have not.
Of course.
That will show.
Okay, okay.
On the
Now, my lord, kindly, my lord. I am, my lord, now, my lord, first on the order. The order has, my lord, come to two findings without considering the material on record. On this ground alone, my lord, the entire order should go.
Yes.
That is my submission. And my lord, it is on the face of it, my lord, contrary to the law. Now, my lord, kindly see what I cited to your lordships, my lord, was a decision, my lord, of the English courts. My lord, this, my lord, has received, my lord, approval, my lord, by the Supreme Court, my lord, which is, my lord, reported in 1981, 3 Supreme Court cases, 333. My lord, paragraphs 44 to, my lord, 47. My lord, in, my lord, paragraph 46,
Yes.
lordship will find my lord, your lordship will find, my lord, third, my lord, the rule as regards duty of utmost good faith on which received further and closer consideration in so and so. Ibrahimi, my lord, which I, my lord, cited. And then para 47, my lord, in his judgment in Westbourne, Lord Wilberforce has referred at 2 places to the decision in Blissett and Daniel, which is recognized as a leading authority in the law of partnership on the duty of good faith, so and so. Then, my lord, 48. The fact that the company is prosperous and makes substantial profits is no obstacle to its being wound up if it is just and equitable to do so. Then, my lord, kindly come to, my lord, paragraph 50.
Yes.
My lord, this is, my lord, from Kalinga, my lord, which also, my lord, referred to, my lord. Where is Westbourne? I'm on Westbourne, no? Now, my lord, kindly come to 1924 All England Report 200. নেবে কপি দেন দাও দুটোই দিয়ে দিলাম I don't need it. আছে তো কভার করে কপি নেবে জুনিয়রদের একটু বলো বই পড়তে My lord, this is from the reprint. My lord, I used to make him read, but my lord, he should pass that on. And none of, my lord, nowadays his juniors are doing so well that they don't have time to read. Only, my lord, yell at each other.
Jurisdiction has become like that, my lord,
Where, my lord, they are practicing, unfortunately, my lord, it's become, my lord, I called it, I told, my lord, the tribunal that, my lord, this is, my lord, center for filibuster.
Absolutely.
That's my
what's,
lord.
my lord.
It's really sad, my lord. This branch of, my lord, the law has gone to tribunals, and my lord, it has been a complete disaster.
When I came in, my lord, and this was a branch of law which was really, my lord, at least I find it very interesting, my lord, and really, my lord, which was flourishing. With regard to, my lord, company matters and.
That is the problem nowadays with the tribunal.
Absolutely.
Big problem.
That is the problems with the, you know, not
And then
not
also
on-
take
not
it away, my
only
lord.
the company, the other
Other
tribunals.
tribunals also. Correct. Correct. And my lord, also taking it away at a distance, my lord, that is also, my lord, kind of ensured that, my lord, it's just totally away, my lord, from, my lord, what, my lord, is really, my lord.
Correct.
Practice of law.
My lord, the idea is to weaken, my lord, the courts, and my lord, weaken, my lord, the, my lord, tribunals. So that, my lord, the three wings, my lord, of, my lord, are, yes, my lord, the judiciary, the legislature, and executive. My lord, one pillar, my lord, gets, my lord, weakened. Because that's the only pillar, my lord, which has stood up in the past.
That is the
Yes.
thing we are the facing
My lord,
problem.
that's, my lord, what I'm really, my lord, worried about.
That's we are
And
facing
that's
the
happening. My lord, it happened at the emergency. Now it's happening, my lord, without the
More than
emergency.
that.
But without any emergency. So, my lord, we are, my lord, worried. My lord, hopefully, my lord, things will work themselves out. What? My lord, kindly take, my lord, Lord Shaw's, my lord, opinion. My lord, 202, my lord, Placitum I, my lord.
Yes, got.
My lord, under this directorate, the business of the company appears to have been energetically managed and to have amassed considerable profits. The arrangement of the capital was this. The total amount was £40,000 in £1 shares. 20,000 of them were allotted to Mrs. McLaren. Of the remaining 20,000, 10,000 should have gone to Mrs. Locke and 10,000 to Mr. Roger. Mrs. Locke, however, was allotted 9,999. Roger was allotted 9,098. The three shares left over were allotted to Mr. McLaren and one each to Yearwood and Mrs. King, who were nominees, so and so. This was quite a natural and proper arrangement. But of course, in the event of a division of opinion in the family between what may be called the McLaren interest on the one hand and the interest of the nephew and niece on the other, the preponderance of voting power lay with the former. It is thus seen, kindly mark the words, preponderance of voting power. It is thus seen that although taking the form of a public company, the concern was practically a domestic and family concern. This consideration is important, as also the preponderance of voting power just mentioned. And then, my lord, the exercise of the right. I'm not, my lord, going into that, my lord, right now. Then, my lord, 1999, two All England reports, 961. My lord, it is Lord Hoffman's judgment. My lord, in Rye, my lord O'Neill and Phillips. What is this? You can't.
Yes.
You people find that.
This copy is also there.
I forget it. I'll remember from where I was. Can't keep reading it 25 times. Yeah. My lord, in England, my lord, after my lord section 210, my lord 459, my lord, was enacted, where the language use was not oppression, but my lord unfairly prejudicial conduct.
Okay.
Now, my lord, Saul and Harrison, etc., were referred to. Kindly come to 960. My lord, Placitum Age. And my lord, oh sorry, my lord, your lordships, my lord, copy, my lord, it's 1099. Where?
1092 starts.
What are you reading?
My
My lord, I have given. My lord, kindly take the weekly law reports. My lord, 1999. My lord, one weekly law reports, 1092, my lord, which has been cited.
Yes.
Now, my lord, kindly come to, my lord, In that, my lord, there is, my lord, at 1098, my lord, where, my lord, Lord Hoffman
Yes.
Oh, sorry, sorry.
It is there.
Oh. No, air का चलेगा हाँ? ये एक मिलेगा और नहीं मिलेगा My lord, in section 459, Parliament has chosen fairness as the criteria by which the court must decide whether it has jurisdiction to grant relief. It is clear from the legislative history that it chose this concept to free the court from technical considerations of legal right and to confer a wide power to do what appeared just and equitable. But this does not mean that the court can do whatever the individual judge happens to think fair. The concept of fairness must be applied judicially, and the content which it is given by the courts must be based upon rational principles. My lord, kindly see the word. As Justice Warner said in Cade and Son, the court has a very wide discretion, but it does not sit under a palm tree. My lord, palm tree justice. My lord, yes, my lord, we have, my lord, the banyan tree. Then, my lord, although fairness is a notion which can be applied to all kinds of activities, its content will depend upon the context in which it is being used. Conduct which is perfectly fair between competing businessmen may not be fair between members of a family. In some sports, it may require at best observance of the rules. In others, it's not cricket. It may be unfair in some circumstances to take advantage of them. All is said to be fair in love and war, so the context and background are very important. In the case of section 459, the background has the following two features. First, a company is an association of persons for an economic purpose, usually entered into with legal advice and some degree of formality. The terms of the association are contained in the articles of association and sometimes in collateral agreements between shareholders. Thus, the manner in which the affairs of the company can be conducted is closely regulated by rules to which the shareholders have agreed. Well, this is one normal, well, commercial. Now, kindly see secondly. Secondly, company law has developed seamlessly from the law of partnership, which was treated by equity like the Roman societas as a contract of good faith. One of the traditional roles of equity as a separate jurisdiction was to restrain the exercise of strict legal rights in certain relationships in which it considered that this would be contrary to good faith. These principles have, with appropriate modification, been carried into company law. The first of these two features leads to the conclusion that a member of a company will not ordinarily be entitled to complain of unfairness unless there has been some breach of the terms on which he agreed that affairs of the company should be conducted. But the second leads to the conclusion that there will be cases in which equitable considerations make it unfair for those conducting the affairs of the company to rely upon the strict legal powers. Thus, unfairness may consist in the breach of the rules or in using the rules in a manner which equity would regard as contrary to good faith. And that, my lord, Ibrahimi, my lord, yes, my lord.
Consider.
My lord, I can stop here, my lord, today.
Yes. How much time will take, Mr. Further? How much time will further take?
My lord, about 2 hours, my lord.
Further?
Yes.
Next Wednesday.
When counsel for the applicant has argued the matter at length,
Sokale, এটা দুপুরে হবে।
but due to paucity of time, hearing could not be completed. तेरा है ना?
My lord, either 2 or 3, my lord, any Wednesday.
On 20th August at 3 p.m. 3 p.m.
Next Wednesday.
Next Wednesday.
Yes.
20 at 3 p.m. 3 p.m. Yes.
This company has gone into liquidation
Yeah.
pursuant to the order passed by this honorable court in
Yeah.
my application. The official legator has come before your lordship with several applications, payment of disbursed bank, secured creditor or security guards like that. But my submission was direct upon the official liquidator to sell out the assets of the company in liquidation and disburse the amount to the creditor.
Let
But
the
that,
report-
my
who is
lord,
the
has
pen?
not
Where
been
is
done.
the official liquidator?
It is here.
New Central. Lordship, there are three applications, 6, 7, 8. First one is CA 11.
Item number?
6, 7, 8.
Yes. The six
First,
is
yes, first is complaint matter, Lordship. Your Lordship has given a direction upon us to serve a notice to the director. We have served upon them, but 2 has returned, Lordship. Lordship, I am showing the track.
how many directors are there?
5, Lordship. 5, Lordship.
You have sent the notice to all?
Yes, Lordship. No, one has earlier received, one has died, Lordship. If your Lordships kindly see the last order, Lordship.
Upon Sipai Ram,
18th June. 18th
proposal has been
order.
written with the endorsement left.
Yes, Lordship.
No report with regard to the accused number 1, 2, and 3.
Again, we have served, Lordship. If your Lordships kindly see that. তুমি পেছনের গুলো দেখাও আইটেম রিটার্ন বলে যেগুলো এসছে One, 2, 3 return, Lordship.
Item delivered, sender, return. Item delivered, sender. Item delivered to addressee. One is delivered.
Yes.
To whom it is delivered?
Lordship, one is Nandodulal Dotto, that is returned. Alok Palit returned, Lordship. Ashok Dev returned, Lordship. Back to that post office, I think
Yes,
so.
written answer.
Yes. And one is died and other one died. Respondent number 4, 4 or 5. 5 died.
No, with regard to this report.
Yes.
One is showing the delivered. Address item delivered to addressee. To whom it is delivered. And you see the last one, last report, last track report.
One is delivered, no, Lordship. If you Lordship, I have only one copy
So this
with me.
see this and where is the receipt? To whom it is addressed?
It is not.
Where is the postal receipt?
পোস্টাল রিসিপ্টটা আছে আপনাদের কাছে অফিসে আছে হ্যাঁ এইটা কার উপরে ডেলিভার্ড হয়েছে সেটা তো ঠিক না অশোক দেব
How? Where is you have to file either you file affidavit of service.
Yes. On the next date I have filed. I will file, Lordship.
Yes.
Direct them to proceed in liquidation. This
He's
matter I have
not.
nothing to say.
Achha, in this matter you are not there.
Nothing. But in jail, my lord, the
Okay.
liquidator is
And
here. Liquidator of the company.
second is item.
This.
Yes.
Item number 6. Counsel for the official liquidator submit that the notice have been sent to the accused persons, but only one notice is served and another has been returned unserved. Police counsel for the official liquidator is directed to file affidavit of service on the next date fixed. Let the matter appear on 20th August for filing affidavit of service.
Next is item number 7.
Yes.
That is for the security expenses, Lordship. On last occasion, your Lordship has given us a direction to serve upon the bank on 4 secured creditors. I have served, all of them have received, Lordship. Today, I do not know whether they are appearing or not.
One of the secured creditors.
If
Lordship,
Lord-
I may be permitted to address your lordship virtually, your lordship.
Yes, yes, yes.
On respondent number 4, your lordship, Indian Bank.
Who is appearing for the IDBI? Anybody is appearing for the IDBI? Indian Bank?
Indian Bank, your lordship, back to appear on behalf of the Indian Bank, your lordship.
You are appearing for the Indian Bank.
Lordship.
And Asset Reconstruction Company? And Industrial Finance Corporation? You are appearing.
That means all of them have appeared.
Shalimar Industries?
Shalimar is a company, Lordship, that has gone into liquidation. And Lordship, the thing is that if you
IDBI is not appearing.
IDBI?
But it is. So who is not paying?
Yes.
Paying?
Lordship,
No.
Lordship,
No,
on instruction, I am submitting your lordship on behalf of the respondent number 4, Indian Bank. On instruction, I am submitting your lordship. There was a from the date of liquidation till today, the liquidator has not yet taken any steps for enforcement of the assets, but even not valuation has not yet been done.
Yes,
Nothing of the sort has been done by the
that all is pending before your lordships. They are not paying now. They are saying all these things.
We are bearing
Lordship.
expenses without getting any outcome.
If your lordship's kind.
Okay, you do one thing. Let the respondent file their affidavits disclosing the how many amounts have you opened, or what about the security charges?
Lordship, but the fact remains, Lordship,
Despite of the appeal court order, they have not paid, Lordship.
We are not shying from giving security charges. But kindly see what steps the learned liquidator has taken for disposal of the property. Nothing.
If your lordships kindly come at page 17 and 18 of my report, lordship, if your lordships
even valuation has not been done. No
your
endeavor
lordship-
has been made to put the property in auction.
if your lordships kindly come the report.
Have you received the report of the official liquidator?
No, Lordship, I have only
Of the report to all the parties. Let they come with the if there are any exception to the report, you file the report. Otherwise, I will decide the matter. On
Yes,
the basis
yes.
of the
Despite of the appeals court order, lordship, they are not paid. Lordship, several matters were pending. So,
okay, that for years without any step being correct. They have filed the report. Let the report be served. Take all of you take the report, go through this, and thereafter, if you any exception or what your suggestion, come with an affidavit. I will decide that what is
the stand, lordship? They are the poor security agencies. They are not getting money despite the order of appeal.
amount is already paid.
With
Yes.
regard to the payment of the with regard to the payment of the security charges, let me
Yes,
decide.
yes,
With
yes.
regard to the other, what they have prayer, let they go through the report.
Yes, yes.
What is their grievances? Let they come and affidavit.
Yes.
And who is not paying the security charges?
Valuation the property.
Well, that's why whatever that's why you go through. They have stated whatever in the report. If they are telling that you are telling that the valuation has not been taken care and the property has not been taken care of by the official liquidator, let you come with an affidavit. I will decide that. So I am not accepting this report at this juncture. But now the question is with regard to the payment of the security charges.
That I leave it to you, Lordship.
What are the bills?
Lordship.
Since when you are not receiving?
As on date, 2 crores 65 lakhs and 48,000.
When you have been appointed?
And I am appointed, my lord, in 2019.
And where is the details? Which place you are appointed?
My lord, kindly take item number 8, my lord. That is my application. The application with the security service provider, my lord.
Lordship, 2 crores 96 lakhs 65,000 is due as on February 2025.
Correct.
Now it's August,
Correct.
Lordship.
Kindly come to page 9 of
So
my
how this security is to be realized? Security charges to be realized.
That
How you will realize?
after selling the assets of the company, but in the it's a huge
Please, yes.
It's a huge property, Lordship. Security agency have been deployed there to protect the assets of the. This New Central Jute Mills company in liquidation. We have taken a position. Yes, Lordship.
These are all the banks are there.
Yes.
Correct.
Yes, Lordship.
ERC is also there.
Yes, Lordship.
So whether they have
Other creditors also there.
Other creditors are also.
So now, unless and until the matter is decided, who will pay the security charges?
That security agents, secured creditors, Lordship.
Lordship, may I, Lordship, may I assist
They
your
were
Lordship?
paying, Lordship. If your Lordships kindly come at my report, Lordship, page 17. March 2025, I have filed a report, Lordship.
My lord is looking my application.
দাঁড়াও আমাকে একটু বলতে দাও।
Page 17.
Yes, Lordship. Paragraph 26, I have stated everything, Lordship.
Proportionate amount to be paid
Yes.
by the secured creditor.
RC, Lordship, ratio, Allahabad Bank, IFCI, IDBI, Lordship. They have paid, RC have paid 1 crore 64,018 and Allahabad Bank 3,22,167, IFCI 2 crores and IDBI 46 lakhs. They have paid, Lordship. Amount paid by the, these are the proportionate amount, and amount paid by the secured creditors, Lordship, there is a column, third column, Lordship. That has been paid by RC. Second one is Allahabad Bank, 1,94,000, IFCI 11,80,000, and IDBI 42 lakhs. They have paid, Lordship. Now this has due amount yet to be paid by the secured creditors, Lordship. These are the due. Last column. These are the due.
2,96 lakhs.
Yes, and total security expenses up to February 2025 is 4 crores 4,57,000 and minus total amount paid by the secured creditors, which we have deducted, and 2 crores 96 lakhs is due as on February 2025.
Correct.
So let them pay, Lordship.
So when the last payment was made?
Last payment was made.
As per my record, my last payment is this one 17th of June 2022.
Yes.
Yes.
30 guards are employed, my lord.
Kindly
Not a single
consider
penny,
this
my lord.
decision was taken for this ratio in 2018. From 2018, we are now in 2025.
Correct.
No steps are being taken to sell these assets.
No, Lordship, that is not a.
Let one. Yes.
But
Okay. You filed the reply.
Substantially.
You filed reply.
Lordship, yes, Lordship, subject to. Your Lordship, there is no dispute by the learned official liquidator that the secured creditor is not paid a single penny regarding the securities payment. But kindly appreciate, Your Lordship, the predicament of the financial creditors as well also. Because the company is in liquidation, there's a property.
That's why what is the contention of this official liquidator? They have disclosed in their report.
Yes.
What is your predicament? You give the exception to the report.
Lordship,
An affidavit. And I consider with regard to that, if you are alleging that the official creditor has not taken any steps for sale of the property or whatever it is the property, then the court will pass appropriate.
Obliged, Your Lordship, obliged.
Were filed by the walkers and all.
Where it was filed.
Lordship, there is an order, Lordship. If your Lordships kindly come at page 24 and 28. Page 24. Division bench order, Lordship, that appeal is dismissed.
Dismissed.
Accordingly, all appeals and connected applications and all are dismissed. When the order was passed, 2019, Lordship.
So, oil is free to move.
The official liquidator pointed out that the secured creditor of the company in liquidation are unwilling to provide the security guards to be engaged to protect the assets of liquidation. The official liquidator will put the secured creditor on notice that the court may allow the official liquidator to leave the assets unprotected unless the secured creditor provide funds of security guard. Yes. Record and all. The report filed by the official liquidator bestowed upon all the secured creditors within a week from date. Full stop. The secured creditors are at liberty to take exception to the report, if any, within a week thereafter. List the matter on 3rd of September 2025.
Obliged, your lordship. Obliged.
You are
Lordship, I am
creditor
told,
as well as unsecured
Lordship,
creditor.
I am told that report has been served to the secured creditor.
Oh, it's served. Where is the report? That's why, madam, your official liquidator not coming with anything. I will pass a strict order.
That we have served.
You have served. Where is the affidavit of service?
In that, on the next date, I shall file.
I have not received the report.
Yes,
Coming the person who are and coming giving instruction. Where is the affidavits?
I shall file. I apologize.
This is not the way to go, submit before the court. Henceforth, I will not accept any of the document without the affidavit of service.
Yes, Lordship.
The verbal instruction the court will not accept. Tomorrow he will be transferred, he will retire. Who will take the responsibility of that?
Yes.
Yes, next.
Obliged, your lordship. Obliged.
Eight is that.
It is an application filed by the security agency, my lord, seeking the payment, my lord. But it is
So I am passing an order to withdraw your security. Because they are not paying you, withdraw your security.
30, my lord.
And with regard to the pendency amount, that will be decided this court. Who has to pay? Let all the what can be done? Your official liquidator sitting tight over the matter, not bringing the matter to the court.
Well, there is an official
2 crore, 4 crore amount is pending.
Yes,
Where is the official liquidator?
But Lordship, that the thing is that they are not paying. That's why and valuation.
Well, there is an official liquidator established.
After 2022, now we are on 20. What the official liquidator is doing? Let them.
No, what happened in the meantime? Several applications and matter was not taking up.
What the last division bench? What the division bench has passed an order? Division bench has passed an order. If the liquidator is not able to collect the security, let the land be go free. Let the land go free. So I am freeing the land.
Land will not stolen.
So
Again, the
Lordship, valuation application is pending before your Lordship. That's one is also pending, Lordship.
2022, now we are 2025. He is claiming the 5
They
crore.
are not paying. We can't pay from
My lord,
our
there is an
own pocket,
official
Lordship.
liquidator
Lordship is
establishment
finding
fund, my
concern.
lord.
Withdraw. I am passing an order. We withdraw the security.
If
Let the official liquidator face the music.
Lordship, next day I shall file a affidavit of service and everything, Lordship. Lordship, kindly action.
Let the report be circulated at our cost, if such being so.
My lord,
This
there is
matter
an
will be taken along with this one.
established fund, my lord. From that fund, my lord, there is earlier occasion where some.
You are also sleeping since 2022. Now when the matter is settled, you came with the application after 3 years. That is a bad.
My lord, we have repeatedly, my lord, intimated the official liquidator, my lord. In spite of that,
Come on, 3rd September. I will see the report, then I will pass appropriate order. And tell your official liquidator if he will not make any arrangement within these 15 days, I will pass any order for releasing the security guard from there.
But
a copy
Lordship,
of the report be served to us.
how can we pay, Lordship?
So you take, where is the letter to sending them, please pay the amount? Where is the request?
So many times,
Where is that?
Lordship. I can show you
No,
on the
bring
next
all the
date,
things on record.
everything I can show your Lordships. That several times we have
The
requested
poor
them
persons
to
are
pay.
taking care of your landed property and you are sitting tied over the matter.
Lordship, no, Lordship. We have requested them several times to pay. They are not paying. Now they have come with this plea.
Okay, let them
That
come.
official liquidator's office
Yes,
is
next,
not coming.
next.
Obliged, your lordship. With your lordship.
Yes.
Your Lordship, item number 9.
Yes.
Your Lordship, I'm appearing for the respondent. My junior is there, Your Lordship, to hand over the hard copy of the affidavit in opposition filed by the respondents.
Who is for the respondent?
Lordship, I am for the applicant.
You are for the applicant.
I'm for the respondent, Your Lord.
Yes.
Yes.
What you filed?
Affidavit in opposition, Your Lordship.
Why? Yes. Have you received the copy?
Yes, my lord. My lord, this is our reply.
You are filing the reply, but they have filed the two opposition, CP1 and CA1.
This is
9 and 10, Your Lordship. 9 and 10.
Yes.
This is for CP1. Lordship, on 21st January, Lordship had granted an extension of interim order for in that order it was mentioned that the ROC shall be presented before this court. We have intimated the same to the ROC, but they haven't been able to come.
Your Lordship, we are already represented today.
We are for the ROC.
Your Lordship, we are represented today. My junior is there, Your Lordship, physically.
They're here. They file the affidavit. You file the reply.
Okay.
Argue.
Lordship, in that case, I was interested to get an extension of interim order.
Why? No, I am. That's why I put the matter within 10 matters. So the matter is to be no extension. Every time you are taking extension or not coming for hearing.
Yes, my lord. I just got the brief today.
Who is leading you?
Sorry.
Who is leading you?
I'm led by Mr. Ratnanko Banerjee, sir.
You? Mr. Banerjee was here.
Yes, my lord.
Affidavit in opposition and an affidavit in reply filed by the parties be kept with the record. List of what interim order you are enjoying, madam?
Lordship.
What is the nature of the interim order?
It was dated 21st January. It was written that the court had directed registrar's company to appear before the court. It is only written there, nothing more. And they shall not take any steps without intimating this court on our behalf of the returnable debt.
Already also shall not take any steps without intimating the court. What steps you are going to take, madam?
Your Lordship, this is a offense, Your Lordship, which can be compounded, Your Lordship, if they pay the penalty, Your Lordship, as I have been instructed by my client, Your Lordship. So this is only the
Go with the ROC and compound the offense. They're telling that you compound the offense and pay the penalty. What about the penalty?
Can be granted for another week.
For what?
I just
come with the penalty slip before this court. I will dispose of. I will clarify this order will not affect for compounding the offense by the parties by paying the penalty amount, if any. Let the matter appear on 20th August 2025. Interim order is extended till 20th August 2025. Come ready on that day. I will not extend the interim order. And go to the, tell your client to go to the ROC. If they are compounding the offense, then let it compound or whatever it may be.
I'm so grateful, Lordship.
Yes. Item 11. None appears on behalf of either of the parties. Let the matter go out of the list. Next.
12, I appear on behalf of the official liquidator, Your Lordship. I'm led by my senior, Mr. Ronoji Chaudhary.
Yes. Let the matter go out of the list.
But I'm paying for the applicant, my lord.
So you, either argue.
Well, I'm only paying for one.
Go out of the list. Yes, next. Call the 30.
Let me proceed with this. But it's a long pending matter, my lord.
I have seen you argue before the other court for the long time. Thereafter not completed, then the part head has been released.
Yes, I did send the before the Justice Kapoor to
Ah.
release the part of.
So you're mentioning before this court only for adjourning the matter?
No, not at all.
So why?
Not at all, my lord. It's a difficulty. Otherwise, my lord, I am proceeding, my lord. But kindly, my lord. Kindly, my lord. You know,
Let the matter appear on 27th.
I'm grateful, lord. I'm grateful.
Next.
My lord, I am
My
appearing.
lord, I appear for Otonu Datta, my lord. The connected matter, my lord, kept on, my lord, next week, when Mr.
When it,
Bose is arguing.
when it is fixed.
It's not,
Lord, this is a
my lord,
matter
20th, my lord, 3 p.m. 20th, 3 p.m.
of property demarcation, my lord.
Hey, just a minute. 20th
Yes.
3 p.m.
This is altogether a different matter.
It is altogether a different matter, my lord.
तो हमको बताया क्यों नहीं वो जब बनर्जी साहब मुखर्जी साहब वाला फिर हम 2-3 पेज रख दिया.
My lord has kept, my lord, this matter at 3 p.m. my lord, last week.
No,
Mr.
this,
Bose was arguing, my lord, the will.
no, this matter is
Re-
not, my lord. This is a CP.
No. There is some other difficulty the court is.
कौन सा?
One property is left or to be sold, and that is to be demarcated and
20
partitioned.
तारीख को 2 बजे 3 बजे कोई मैटर फिक्स है? So the whole matter fix why you are not informed? See, I need time. I fix the 3 p.m. This matter is also fixed 3 p.m. That there is a overlapping. You're not maintaining the diary. Not ये नहीं हम बोल रहे हैं. 20 तारीख को
পুরঞ্জয় সার্ভেয়ার ওইটাই তো My lord, in this matter, your lordship was pleased to appoint a surveyor. My lord,
matter.
My lord, C is 26 of 2020.
Item number 13.
Yes.
Yes.
My lord, the surveyor, my lord, requested the official liquidator to provide, my lord, 2 weeks more time, my lord.
No, item number 13 is CA number
26 of 2023, my lord. This is my application.
There are altogether 3 applications are running in the book.
Yes, my lord.
One is the dispute pertaining.
Out of 3, my lord, kept my lord, item my lord, IA 27 my lord on next week, my lord, 3 p.m.
आप लोग डायरी नहीं रखते. ओवरलैपिंग हो गया.
My lord, item number 22, which was hard, my lord, that has been fixed on 20th.
Which one?
My lord, CA 22.
CA 22.
Ah.
22.
That was fixed on 20th.
Okay.
That was hard on last.
That was fixed on my lord, next week, 3 p.m.
Now this item number 13.
Item number 13, my lord, your lordship was pleased to appoint Puranjoy Kumar and Associates
Yes.
for the purpose of demarcation.
Correct.
My lord, he has requested me to, my lord, take another 2 weeks time, my lord. He is not well. So that is the, my lord, the email we have received, my lord. Kindly see, my lord.
So I am deleting his name from the
My
our
lord.
list.
My lord,
Or
kindly
his
see.
list if he's not able to do the work.
My lord, kindly see.
Inform him. If he's not able to do the work, I will recommend for deletion his name from the approval list of the special officer.
Very well.
The third time.
And my lord, on last occasion, your lordship was asking me that whether the cost of demarcation, who will want the cost, my lord. That has already been decided, my lord. This is the order, my lord, on 19 September 2024.
One out of the available funds of company.
My lord.
No. As per the prayer made by the special officer.
My lord, speak.
What? Commissioner? Surveyor?
Surveyor.
Surveyor. The case is adjourned. Let the matter appear on 27th.
Grateful, your lordship.
Then this becomes overlapping with Mr. Mukherjee's matter.
Which one?
IA 22.
This is with regard to demarcation. That is,
No. The other IA that Mr. Bose was arguing.
that is with regard to your title. Now here with regard to the demarcation.
No, the timing. My lord has kept Mr. Mukherjee's matter, my lord, I hope at the same time.
Now then I will see what is to be done.
Very well. I leave it to your questions. Very well. 13 and 14, my lord, both items.
Yes, yes, 13, 14,
14 is another aspect, my lord.
Yes, 14 is another application.
14, my lord, in the 14, they are asking for the debenture holders to get their share, who has already accepted on the basis of the, my lord, as a contributory's legal heirs, and also purchase the property. He is
Yes,
the
sir.
applicant. He is also represented by Mr. Moinak Bose. My lord, these
today no
affidavits are complete, my lord. My lord, unless, my lord,
that is decided how it comes.
my lord, that is there. So
Let
let
it come on
let
27.
it be posted after some time, because it's difficult.
Come on
for the
27,
parties.
we'll see to that. Come on
I'll leave
27.
it. I'll leave
Oh,
it.
yes. Sir.
Very well. Obliged. Obliged.
Let the matter appear on 27. Yes, next.
Lord, I'm appearing, my lord, in this case, my lord. Lord, in this case, my lord, I have a twofold prayer before you, lord. First, my lord, directing the official liquidator to execute a deed of conveyance for a sale in respect of plot number 12 of dag number such and such, Moja such and such, and also second prayer is to direct the official liquidator to disburse the claim of settled amount of rupees 22,000. Now, what has actually happened, my lord, in the year 1976, my lord, I have purchased this property, and when the company went into liquidation in the year 1978. Now, my lord, thereafter, my lord, by the order of in the year 1985, my lord, by the order of Calcutta High Court, my lord, the directed the official liquidator to sell the assets of the company. My lord, my husband died, my lord, in the year 1987. But thereafter, my lord, I have regularly pursuing the matter before the official liquidator, my lord. My lord, official liquidator's last letter, my lord, if your lordship will kindly see, my lord, page number 41, my lord. Page number 41, the official liquidator's list is not with reference to the above. Understand, I am directed to state that instead of applying this office for registration as well as execution of deed of sale in respect of subject property which appears to be sold by the erstwhile company prior to the date of order of its winding up in favor of your husband, Shiban Kumar Dotto, it will be appropriate to apply before the Calcutta High Court for necessary directions upon official liquidator to High Court in this regard. Now, my lord, I have paid the amount, that is the page number 11. And my lord, another regarding second player, my lordship, if your lordship will kindly see, my lord, another document, page number 37, my lord. Page number 37, my lord, they are admitting, my lord, they will be there's a due of rupees 22,674. My lord, page number 37, my lord. And next, my lord, you are hereby informed that your claim against the above named company has been allowed at a sum of rupees 22,674 as ordinary preferential claim. This amount, my lord, has not been disbursed to me till date, and also, my lord, my first prayer is to, my lord, register, my lord, but they.
The prayer.
The judges summons, my lord, the two full prayers. My lord, plot number 12 and 13. 13 has already been registered in my. Sorry.
Leave be granted the official liquidator, High Court, to register the executor sale deed in respect of plot number 12.
Plot number 12, yes. Which I have already paid prior to liquidation. 76 I have paid the amount of registration. Now, company went into liquidation 78. My lord, my husband died in the year 87. 85, my lord, there was an order by virtue of which, my lord, not the official liquidator was directed to sell the assets. And my lord,
yes, yeah. What is your
Lordship, regarding 22,000, we are ready to pay. That is the claimed amount. But regarding the registration, I am objecting because after 46 years they are coming. Because the entire asset, this is plot number 13, was within our assets, and we have that was subsequently registered. But plot number 12, your lordship, that is not within our assets list of assets, your lordship. Everything was done, the execution and everything was done, sale proceeds, everything was done prior to liquidation, your lordship. So regarding prayer C, your lordship, I am objecting. Prayer D can be allowed. After 46 years, because 76 to 2019, 2020, they did nothing.
Okay, you filed a report.
Lordship, we have filed their opposition also.
You filed?
And they have filed the reply also.
Where is the opposition?
No.
It is only on 2019 we came to know. At the first time.
Nineteen 1990.
Receipt করে check it.
So where the plot number 12 is recorded now.
Lordship, erstwhile it was recorded in the predecessor interest about in name of her husband.
Correct.
Who has expired. Now
Correct.
subsequently the wife has come up. Now we are not in a position to inquire also because we are not the custodian legacy of this custodian legacy of this particular piece and parcel of the land.
Because you are admitted.
We have only admitted the claim. We have admitted that plot number 13, whatever is there, we have done.
The paragraph 4, page 4, paragraph 4. The deponent stated that admittedly it is a matter of record that the husband of the applicant so purchased the plot of land bearing survey number, plot number 12.
That is from the record what they have submitted.
So,
Lordship, that may be the position, but the point is that this piece and parcel of property at this juncture, we cannot go for execution because
property belongs to whom?
Property belongs to Shiban Dotto, my husband, my lord. Thereafter, my lord.
If it belongs to you, why you are coming for the sale deed?
No, my lord, property, my lord, we have paid for paid that amount, my lord, paid to the erstwhile, to the homely, the office, the office.
To whom you have paid?
The company, my lord, we have paid. The company went into liquid. I mean, I have paid, my lord. I have paid 76, my lord.
Now we are on.
No, now we are 25. But
entitled to pay a refund of the amount also.
No, Lordship will kindly say, 1995 also, I have annexed in the opposition, my lord, reply, my lord, page number 9, my lord. Page number 9, Lordship will kindly say, have a look, the documents, page number 9 of my reply, my lord. Regarding the discussion we had with in 1995, most respectfully state that the deed of conveyance respect of the land in which the sold.
So what is happened 95? After 95?
But thereafter, I'm not pursuing the matter. Thereafter, I'm
okay, let it be kept pending further 20 years. You wait.
I understand.
And come after 25 years. Then your son will come.
I understand.
Or your grandson will come for claiming the property. Until that my grandmother has filed an application, it is kept pending. Now I am entitled for the sale deed.
I understand.
You take the money, 22,674. What can be done?
That is also time part to some extent.
That's what I'm telling.
2006. That is also time part.
I'll leave it to you.
But you are denying it. Kindly come to the paragraph 10.
Paragraph 10.
Yes.
Opposition.
7, 8, 9, 10, 11, and 12.
Yes. In this regard, the deponent further stated that
Says that the applicant purportedly seeks for necessary direction upon the official liquidator to pay a amount of rupees 15,000 and off, being less than the purchase man is 6,000 and off for the admitted amount of rupees 22,000. It is submitted that the 22,000 has been settled on the part of the, but under no circumstances the disputed amount 15,000. My lord, this 15,000 they are claiming 22,000 along with 15,000.
No, that where is no only they are claiming the
15,000 cannot in the application also, your lordship. The 15,000 of that amount has also been sought for, which we cannot pay.
No, where D?
Yes.
Only 22,000. 674.
22,000, your lordship, since the admitted claim, though it's time barred, we are ready to pay as per the instruction.
The applicant has filed the present application being CA4 of 2025 in CP 319 of 2019. What has happened to this old CP 78?
Lordship, that has to be inquired because
No, I have a given direction. I think 130 cases are pending since 1968. I have given direction to submit the report to me.
we can go for dissolution also.
Yeah, whether it has resolution has been passed or not, resolved or not. If it is resolved, the total cases to since 68, all the matters are pending.
This pertains to 78.
I chalk out 130 cases are pending with regard to the company matters. Since 68, 78, this is one of the 78. So if it's telling that it is dissolved, what remains in the case? So why it is not bringing up before this court for disposal of the company matter?
Lordship, perhaps this matter has not been taken up properly. We will see to it.
This I directed to the official liquidator. A notice has been sent.
My humble request would be, it would be 2 weeks they will submit.
Correct. You submit that. I will place all the matter. If it is liquidation is completed and all these things has been completed, if the it dissolved, what further remains? क्या बोला? The present application being CA number so and so and CP number so and so, praying for a direction. I'm praying for a direction to the official liquidator of this court to execute the deed of conveyance with respect to plot number 12 under RS Dag number 1753 in RS Khetan number 48 Muaza Nursing Bad and RS plot number 3263 and 3427 under RS Khetan number 3301/11415 of Muaza Asansol municipality consisting of land at measuring take quotas 9 chitaks more or less adjacent to the plot number 13 in favor of the applicant. Police stop. Counsel for the applicant submit that. The husband of the applicant, namely Shiven Kumar Datta, since deceased has purchased the plot on 4th of August 1976. He submits that during his lifetime he has paid the amount of rupees Where is the receipt? Money receipt?
No, receipt is not.
37. No, it is the admitted claim.
Page 27.
Not money receipt in the page number 11.
11. No. 11 of
the application. Page number 37 is not.
The admitted.
Is the admitted claim.
Where it is? Paid an amount of 22,000. How you are claiming this 22,674? If we claim the amount of 22,000.
The admitted claim
is 22,674. and he has relied upon the receipt and the notice of admission of proof issued by the official liquidator of the High Court in the above matter on 4th of April 2006. 2006. Full stop. He submitted that after the death of Siben Kumar Datta, the applicant has time and again requested the official liquidator for registration of the deed, but till date deed has not been registered, and as such he prays for a direction upon the liquidator for registration of conveyance deed. Official liquidator has filed an affidavit in opposition. Stating that it is not possible, stating that as per the case of the applicant has paid the amount in the year, and the husband of the applicant has paid the amount in the year 1976, and now after the period of more than 30 years, the applicant has filed the present application for registration of sale deed, but it is not possible for the official liquidator for conveyance deed. For the official liquidator to register a conveyance deed, as there is no record available with the official liquidator with regard to the aforesaid lender property. Full stop. Official liquidator. Full stop. Full stop. This court find that it is admitted that the 22,674 is lying with the official liquidator, which has been admitted by the official liquidator in the notice of admission of proof dated 4th of April 2006. Considering the above, this court find that the applicant has come after 30 years for registration of conveyance deed with respect of the property in question, but it is a specific case made out by the official liquidator that where about the property and the details of the property is not available with the official liquidator, and it is not possible for the official liquidator at this stage after the period of 30 years for registration of any conveyance deed. Thus, this court is of the opinion that the amount of rupees 22,674 is required to be repaid, returned to the applicant. Accordingly, the official liquidator is directed to return the amount of rupees 22,674 to the petitioner, to the applicant on proper identification within a period of 2 weeks.
Lordship, 4 weeks to 5 weeks, your lordship, because we have to get ready.
Within a period of 4 weeks from this date. After payment of the said amount, the official liquidator is directed to file the report before this court. This is the matter on 17 September 2024. Yes, next. CA is disposed.
But I am for the official liquidator.
This is my application.
CA disposed है, CP आएगा. हम देखेगा अभी, हम एक को सब निकलवाएंगे.
16 is my application. 16 is an application for permanent stay of the winding up.
Yes.
In terms of the order, we have made the entire payment of the total claim as per the records of the liquidator. Thereafter, order was passed for stay of the winding up. Now, this application was kept pending only for the purpose of the liquidator to file the report to show how much amount which we have paid has been disbursed to the workers and whatever other claimants who were left. Now,
who are you?
I am the applicant contributory at whose instance this order was passed. Now, Lordship's last order is dated
18 June.
18 June.
Yes.
My lord, they were directed to file a report. Now, my lord, the report has come.
But the report, my lord, very shockingly, my lord, the main ingredient in the report is not there, and what is not relevant has been included in the report. Now,
But I
kindly
do
see
not
the
know
report.
how he has got the report copy. I have not given to him.
No, I've got.
I do not know.
तो आपने तो दिया है.
But I am not satisfied with this report. I have requested the official liquidator that this report cannot be
Mr.
filed.
Chaudhary, official liquidator now shifted to the new
Because
bidding at
their
corporate
application
bhavan.
has been
This is
disposed
their
of.
letter.
Their application has been disposed of.
No,
now
no.
it is the
No,
now
no,
it is the
Mr.
terms
Chaudhary,
of
you are
the
not
official
correct.
liquidator and not the court.
Mr. Chaudhary, let me finish. The application is not
Application has
disposed
been
of.
winding up order has been
Sir,
stayed.
Binding up. May I finish?
Have you brought the report?
My lord, this report cannot be filed, my lord. Before I am extremely sorry.
Why it has been served?
I do not know how it has been served, but it should not have been served.
No, may I take two things. One thing, my lord, first of all, Mr. Chaudhary should be clear on facts. Application is kept pending. It is not disposed of. Only order of
Which
stay.
application?
The
CA79?
CA79, I think. CA79
CA79
is pending. So now it is CA9. Now CA9.
CA9.
Now it is
CA9, my
pending.
lord, the winding up order has been stayed.
Yes,
So,
may I finish, Mr.
that
Chaudhary? I have
application
not
has been-
finished. I have not finished. Kindly see the prayers in the judge's summons, my lord, which is there. The final prayer has to be allowed. Lordship winding up order has been stayed. Now the final order is a permanent stay of winding up, and this CA stands disposed of. Now, before that, the court wanted to see what happened to the कितना रुपया दिया था हमने?
1 crore 60 lakhs.
1 crore 60 lakhs we had given to the liquidator to make disbursement for payment of the claimants who had lodged their claim. Not that, to see the report, this application was kept pending by this coordinate bench. Now this report has been served to us. So maybe because the official liquidator are now shifted to the corporate bhavan, which is in Newtown, maybe there is some communication gap. I don't know from which office Mr. Chaudhary is getting instruction.
Two secured creditors payment was given.
And kindly see
Now,
the report.
Only see, my lord, the workers are remaining. 137 people's, my lord, kindly see the year of the winding up application filing 85.
That's I'm telling.
Yes,
85.
I have
So
I
what
have
remains?
no, my lord, I have sent the notice to all the my lord, the workers. Now, my lord, the most of the workers, my lord, the postal return back, and some of them, my lord, postal track report is not available nowadays. My lord, there is some disturbance in the postal authority. Report is not available. So that is the reason for which, and the report which was prepared, it was
How
not.
many workers are there? As per your list?
137.
Okay.
So, my lord,
see, leave aside your postal authority. It is at 85.
Yes.
I don't think your workers
No,
will be
the
available.
winding up order, my lord, very recently stayed.
When?
Last year.
Very recently, my lord,
When we had paid the entire money.
This court.
Yes.
Yes, my lord.
This court is
by the company court, my lord.
My lord, this was stayed when we put in the entire money. That is what I was saying.
Yes.
Stay of winding up order has been stayed. Now
By which order? By which order?
Order दिखाओ. And thereafter, my lord, we had written to the liquidator that now they should hand over the statutory records to the contributory who will not step into the shoes.
Correct.
Order,
When
page
the
12
step-
February.
Huh?
12 February
3rd October.
2025. 12 February 2025 of the coordinate bench.
Yes.
Can we come to page number 2? It is first line. It is submitted that
Disbursement of the official liquidator to the ex-workers so far as balance amount is concerned is in process. In view of the fact the instant proceeding is stayed till further order except to the extent disbursement of
means he can continue with the disbursement.
Yes.
It of therefore the office
That
will not
is the
proceed.
reason for which
So what-
PP is pending. My lord, kindly see the order dated 3rd October 2024 also. Passed by your lordship's coordinate bench.
3rd October.
Yes, 3rd October 2024.
Yes.
I think that was before I deposited the money.
Managers
Yes.
managers check dated sense payable official liquidator is down on the SBI bank. Photocopy be kept with the what is
This
the
is
amount?
when I
Yes,
this
that
is when I
amount-
put in the money, but stay
that
was not
amount,
granted.
that amount, some of the some portions of the amount has been disbursed to the two secured creditors, and only remaining the workers. So 137 workers are there. We have already issued notice, and my lord, some of the workers' claim have already been settled. We have also issued my lord, form number 69 and form number 70. But most of the workers, my lord, no response was received. So that is the reason for which, since my lord, they are the workers, poor workers, since 1985, the winding up order was passed in 1985. So, my lord, I request 2 weeks time to submit a report before your lordship that how much amount I have disbursed to the
No,
workers
that
or
is correct. That is correct.
Yes.
You are telling the 137 workers.
Yes.
Postal receipts is not coming. to
Postal, yes, my lord.
In the meantime, if the workers who have already been settled with
Yes.
you, leave aside
That-
and
that,
with regard to the
my
other,
lord-
you made a publication.
My lord, that is, my lord, that things has not been given in this report, my lord. Wrongly, it was not mentioned
My lord,
here.
may I
So
just
that is the
indicate two
reason, my lord.
things?
I am seeking only 2 weeks time. I will submit the entire documents before your lordships so that your lordships can pass an order if some workers are not, my lord, they are
My lord,
not.
two things. Kindly come to the report as it stands now, paragraph 11.
That
My
report
lord,
is
I have not
applicable
filed.
for-
I have not
That
filed. I have
will
not.
not go into
Dividend, they are asking for payment of dividend. I'm
let the final report be
And
submitted.
secondly, my lord, they have to give the details of the amount which they have disbursed and the amount which is lying unclaimed with them. And only one thing, my lord, lordship, last order, lordship has given us leave to take inspection. They will give inspection of the records and so that I can
You
take.
have already
No, I've
taken
taken,
inspection.
They are not giving
Yes,
inspection.
they have taken inspection. My lord, it
Mr.
was not properly
My
instructed.
advocate is
They have
present.
taken inspection.
The court will not go into that. If
They have taken inspection.
already there is an order.
They have not given
Where is
inspection.
the letter?
Letter is there. We have given.
Where is the letter and where is that they are not given inspection? Where is the letter?
Hard copy to do. We have a soft copy. I cannot read the hard copy, but we have asked for inspection.
Where give it to me.
No, inspection.
This is the letter of 9th
No,
of
last-
20th of May.
Last
and
Monday, my lord,
21st
they have
April.
taken inspection.
That cannot be.
We will, my lord.
This cannot be after the
After
ATPL
the order, my lord. My lord, today we have sent an email saying that inspection was not given.
Why, Mr.
Ask-
You are the senior persons.
Today, my lord, they have sent. I'm
Court
not.
has passed on 18 June. You are issued the letter on April, and you are telling that now.
No, letter was issued after the order also.
Where is that?
My
Show
lord,
me.
I'm showing you.
Official liquidator is present here. I will pass appropriate order.
Letter दिखाओ.
My lord, last Monday, they have taken inspection.
Some of the records are lying in the record room. So I already told him that you take the inspection on Monday and.
If they are not given, my lord, we shall take again, my lord. I can't find the letter in my record. So after the order, but there is the letter.
Counsel for the official liquidator. Press for time to file report. Let the report be filed within 2 weeks. Please the matter on
Post order
27th.
तुमने सुबह मिला है बताया क्यों नहीं? हाँ जी चीज अपने पेट पर रखी है.
Yes, come on.
Lordship is giving after 2 weeks.
27. Next.
I have got the official liquidator here, my lord. My application for dissolution. My lord, in pursuance of your lordship's order dated 2nd April 2025, my lord, I am filing the report. No, last report. If your lordships kindly see page 6, that is the order.
Yes.
Passed by your lordships.
Prayer be is allowed.
Yes. Now, my lord, paper publication only in respect, kindly turns to page 11.
Yes.
This is the only objection, my lord, the official liquidator has received.
Objection against the order of dissolution by the Honorable Court. Who has given this?
This person has, my lord, the property, immovable property belongs to the, my lord, Port Trust Authority. We have handed over to the Port Trust Authority. Port Trust Authority leased out this property. And this Honorable Court was direct the Port Trust Authority that if the lease can be extended, that, my lord, the lessee, he also input a tenant. Now, the tenant is now claiming that there is an objection. So, my lord, if you lordships kindly see, I have stated in my report, paragraph, page 4, kindly see. Why?
Land in question belongs to Port Trust.
Yes. The official liquidator High Court Calcutta in terms of the Honorable Court's order dated 16th or 1998 and subsequent order of the Appeal Court dated so and so, the movable assets were sold to so and so. The Honorable Court of Appeal was pleased to direct the Port Trust to extend the lease in favor of the purchaser since the movable assets were sold as a going concern. In terms of the direction of the Honorable High Court official liquidator, accordingly simply hand over the property in question to the purchaser without any condition. Copy of the Honorable Appeal Court's order, my lord, Annexure D.
Direction of the High Court, the official liquidator has Calcutta according simply handed over the property in question to the purchaser. How?
Because purchaser, because, my lord, residuary period of the lease was sold. Originally, properties belongs to the Port Trust Authority. The property was put up for sale for the residuary period, and we have handed over after the sale is completed. We have handed over the property to the purchaser. So we do not have nothing to do with regard to the in the property. What is happening in the property? We have already handed over.
So what remains?
Nothing remains. So I am seeking, my lord, the prayer C and D of the judge's summons. Prayer C and D, my lord, the
So what will happen to the property?
the property is not belongs to the official liquidator. It was handed over to the, my lord, the purchaser. Because originally belongs to Port Trust Authority. Port Trust Authority leased out the portion of the land to the company in liquidation. That portion of the land was sold by the official liquidator. That is the residuary period. Now, if your lordships kindly see the appeal court's order, the order of the Honorable Appeal Court, my lord, that is Annexure D, page. My lord, that is a long. Yes, my lord, kindly turns to page 20.
If it is so, why you have published the publication creditors, contributors, and stakeholders?
No, before the, my lord, the dissolution, the official liquidator is required to make a publication that if any person is aggrieved by or anything is remaining.
So that's their objection has come. What is his objection?
My lord, kindly see the objection. Page 11. Das Reprographics Limited was having its factory P so and so, including plant and machinery so and so limited by your office at a very low price, and the buyer Capcom Private Limited did not make the payment to the ex-employee.
Yes.
As was stipulated in condition.
Correct.
But sale was conducted as a going concern. So going concern means, my lord, the liability, the purchaser has taken the liability. So the official liquidator has got no liability.
No, official liquidator has no liability, but if it has not been paid, what is to be done?
No. So, my lord, that is the purchaser. He will think about it. My lord, kindly see the annexure A, copy of the rent agreement.
No.
The allegations kindly see.
Kindly see the
Yes.
objection. As per condition of the sale, it was stipulated that the Elephant Tie-Up Private Limited would remove the factory plant and machinery and will make the payment of 25 lakhs.
Yes.
To the workers of Das.
But instead of returning the possession to Kolkata Port Trust, Afcon Tie-Up Private Limited rented out the property for a rental of rupees so and so. So what the official liquidator do after transfer the property? The property was transferred to the purchaser. And the original owner of the property is the Port Trust. It was a leased out property of the company was the lessee. So that lease residuary period of the lease was sold out by the official liquidator in pursuance of the order of the Honorable Court. And the property was, the sale was confirmed as a going concern, taking the liability of the workers. Now the main crux of the agreement, the purchaser rented the property. So what the official liquidator would do? There is no allegations against the official liquidator, but against the purchaser.
Yes.
So, my lord, nothing remains. This objection cannot be, my lord, take as an objection because there is no claim. The entire claim they are asking for the object. They are asking for against the, my lord, the purchaser, not against the official liquidator or not against the company in liquidation.
Who has sold the property?
Company, my lord, official liquidator.
Official liquidator sold to whom?
To purchaser, my lord, the name is mentioned therein. My lord, page 12, my lord, kindly see that Efcalon tie-up private limited.
No. Kindly come to your order. In the page 4. Official liquidator, High Court, in terms of the High Court order dated subsequent order of the appeal, the immovable assets were sold to the Efcalon.
Yes.
Tie-up private limited. Who has sold this property?
Official liquidator.
So,
in person.
So what has happened to this amount? If you have sold this property to Efcon, so what has happened to this amount?
No, that amount has been disbursed among the creditors.
So
that amount has been disbursed among the creditors and the secured creditors. That would be reflected in, my lord, the affidavit filed by the in support of the judge's summons. If your lordship kindly takes up.
What has happened to the workers? What has happened to the workers?
Kindly turns to page 7, my lord, page 5, my lord. I say and submit the official liquidator filed a letter for direction before the Honorable Court regarding disbursement of the dividend 5.80 of the secured creditors regional.
Where from you are reading?
Paragraph 5, page 7. Paragraph page 5, paragraph 7.
Application?
No, of the affidavit filed in support of the judge's summons. My lord, that is the affidavit, my lord, affirmed on 30th January 2025.
Yes. Sold to 50 lakh in terms of the appeal court order.
My lord,
appeal court was directed the officer to pay 12.9 lakhs yes. Pay the
page 4, paragraph 5. If you
yes.
Kindly see, then paragraph
directed the official liquidator to pay 12.50 lakhs to the 211 ex-workers on
was paid.
ad hoc basis. Where is that?
That was paid, my lord.
No, that is the claim objection raised here.
No, my lord, kindly see. On page 11.
So this 211 ex-workers have been paid.
As per condition of the sale, it was stipulated that Efcon tie-up private.
Now leave aside that.
Yes.
This 12,50,000, 211 ex-workers have been paid. Where is that record?
My lord, that report, my lord, if your lordship seeks, then my lord, I have to file a supplementary affidavit with
because he has raised this objection.
Yes.
So if that is different, no, we have to.
My lord, kindly see the objection. My lord, type of objection.
Correct. I appreciate
that purchaser is not being paid.
Not paid, but we have to. The court has to dispose of.
Yes.
So court has disposed. Neglecting this objection.
Very well, my lord. My lord, kindly give me 2 weeks time. I shall give the details of the bank.
This 12,50,000 has been disbursed to all the ex-workers. Where is that?
Yes, my lord, that I will, my lord, intimate. My lord,
if this 12,50,000 ex-workers have been received, with regard to that 25 lakhs, we have nothing to do.
Yes.
So that is your case also.
Yes.
So you have to you have submitted this. Where is that record that you have paid the 12,50,000 has been paid to the 211 workers?
My lord, very well. I shall, my lord, file a supplementary affidavit giving the details.
The official liquidator has submitted the report stating that in terms of the order passed by this court dated 2nd April 2025, the official liquidator has made publication. And on the basis of the publication, one objection has been received from Star Trek Agency Private Limited, wherein it is stated that Efcalon, AEFCALON, tie-up Private Limited, did not make the payment to the ex-employees, as was stipulated in condition of sale to them by the office of the official liquidator, and most of the workers lost their livelihood due to non-receipt of the dues. Full stop. In the application, in the present application, being CA 25/2025, the official liquidator has made an statement that after valuating the two assets of the property of the company in liquidation bracket mein aayega, the said assets and property were sold for rupees 50 lakhs in terms of the order passed by the appellate court dated 9th April 2003 and subsequent order dated 8th May 2003. And as per the direction passed by the appellate court, the official liquidator has paid 12.50 lakhs to 211 ex-workers on ad hoc basis. Full stop. Considering the above, this court finds that a further report is required to be filed by the official liquidator to establish that out of the total sale consideration of rupees 50 lakhs, 12.5 lakhs have been paid to the 211 ex-workers on ad hoc basis.
Paragraph 7 also kindly read, my lord. Some other payments was also made. Paragraph 7.
It is further found that in paragraph 7 of the present application, it is further stated that for the amount of rupees 21 lakh.
Yes, my lord. 21 lakhs.
02.0312, that is 5.80%, has been disbursed to the creditors, namely United Bank of India, now Punjab National Bank, West Bengal Financial Corporation, Regional Provident Fund Organization. In view of the above, the
And my lord, 211 workers also.
that I already take.
No,
and
here
211
also,
workers
yes.
and 211 workers. In view of the above, the official liquidator is directed to disclose all the documents with regard to disbursement of the said amount to the ex-workers and
Creditors, secured creditors.
the secured creditors within a period of
3 weeks, my lord.
3 weeks. List the matter on 3rd September 2020.
I'm deeply pleased.
My lord, on the last occasion, the order was passed, whereby we were directed to furnish a deed to the Lordship. Kindly sees the paragraph 15 of the Lordship's order dated June 11.
Citizen director submit the draft sale deed. Draft deed of conveyance to the official liquidator within a period of 2 weeks.
My lord, this so we have submitted delayed. We submitted, I think, yesterday only.
Lordship, we didn't receive. We have received. We didn't receive till date.
Why so many communication gaps? Every matters.
Yesterday
Parties
only.
telling that it is received.
Emailed it also.
Yesterday we have received it.
Okay, so what do you want?
Now they have to vet it and
Lordship, these 2 applications I'm praying for 3 weeks time to come up again returnable, because there are 2 applications. One is for their for the deed of conveyance to be done, and another application is on our part for the valuation to be done. But there's some predicaments we couldn't make out the valuation of the assets. We are seeking for revaluation.
So before valuation, how the sale deed can be executed?
There are two parts,
I
two
don't
applications.
think we are affected by that.
This is one asset in Kharov, land in Kharov.
That valuation and the entire money is already paid.
Yes.
Entire money, 7.85
Lordship, 4 weeks time may be granted. We will come up with the appropriate report and appropriate position after waiting. PS 68 and 69.
Counsel for the applicant submits that though this court by an order dated 11th June 2025 directed the petitioner to submit the draft deed of conveyance to the official liquidator within a period of 2 weeks from the date of the order, but due to some inadvertence, but the applicant has submitted the draft deed of conveyance only on 12th of August 2024. Counsel for the official liquidator prays for 4 weeks time to complete the process. In view of the above, the case is adjourned. Let the matter appear on on 17th September 2025.
I'm obliged, madam.
The official liquidator is directed to file the report on the date.
68 and 69, both your lordship.
Not ours, not
Application,
ours.
that is also I'm seeking for 4 weeks.
But in that deed is there.
No, it is not the question of deed. That is the question of revaluation. We are seeking
69,
for
Item
revaluation
number
of the
60,
assets.
item number 19. As per the prayer made by the counsel for the official liquidator, case is adjourned. Let the matter appear on 17th.
Much.
For filing report. No.
Not for report.
Okay.
Let us come up with a present position
On
thereafter.
17th September. Huh?
Lordship, in this matter, I am for the official liquidator, Lordship.
Yes.
Lordship, I am praying for 2 weeks' time, 3 weeks' time to file my opposition.
Earlier 4 weeks got given.
My lord, may I file my
Lordship,
affidavit, Lord?
I apologize, Lordship. Lordship, I
Affidavit to file within 4 weeks, reply within 2 weeks. Fix the matter 30th July.
Yes.
So you
Lordship,
filed the affidavit.
Yes, my lord. I have
I'll
served.
reply.
Yeah, opposition, Lordship.
What
They
are-
have filed an application and we are.
No, what you have filed?
I have filed my affidavit, Lordship, as directed by my lord on the last occasion.
Affidavit of?
By the Provident Fund Authority. With regard
Okay,
to
you are
the.
the Provident Fund.
Yes, my lord.
I am for the official liquidator. I am praying for 3 weeks' time to file my opposition, Lordship. In their
The
application.
claim is concerned, which was not.
What about this? You will not take?
I have served.
Yes, yes.
So you will not file reply to this?
Lordship, I am praying for time.
That only, no?
Yes, yes.
Record. Regional Provident Fund Commissioner, that's one. Learned Counsel appearing for the Regional Provident Fund Commissioner. That's one has filed affidavit after serving the copy to the Learned Counsel for the official liquidator. Let the same be kept with the record. Official liquidator prays for time to file affidavit in reply. Let reply be filed within 2 weeks. Please the matter on 3rd September.
I am grateful.
Sir. Lord, this is my application.
Yes.
Lord, this is an application, my lord, at the instance of an ex-employee of the company in liquidation, my lord, seeking transfer of the, my lord, winding up petition to NCLT. The reasons, my lord, that, my lord, this company was a share broking company, my lord. And, my lord, official liquidator has sold, my lord, the immovable assets. And my lord, there was, my lord, my claim was 80,000 rupees. They have admitted at 74,000 rupees, and we have only received, my lord, 4,100 rupees because, my lord, they did not have fund. My lord, since this company was, my lord, a company which was dealing with, my lord, the trading of shares, my lord, this has, my lord, my lord, goodwill. Apart from that, my lord, there are tangible assets in the form of shares which this company was holding of a different companies, my lord. That has not been, my lord, traced out by the official liquidator, not even, my lord, taken any steps for, my lord, sale. So, my lord, my humble submission would be that if it goes, my lord, there will be, my lord, possibility of, my lord, reviving this company based on, my lord, the shares. This will value, my lord, in crores.
Yes.
Lordship, regarding this matter, what my instruction is that some of the assets might have been sold, but I will file a status report to this effect because the entire fact of the gamut of the fact has to be still is required to be asserted. But let me come up after 3 weeks, your lordship, with the proper status report, your lordship, whether it at all can be transferred to NCLT or not.
Counsel for the official liquidator prays for time to file status report. Let the report be filed within 2 weeks.
3 weeks?
Within 3 weeks, leave the matter on 3rd September. Next.
Lordship, if it can be on 17th September, if your lordship pleases.
10th September.
10th September.
22 and
for the workers union blood in this matter.
22 is my my application for on behalf of the Samik Union for their dues, my lord. And the main matter, Sri Synthetic has been assigned to Honorable Justice Aniruddha Roy, my lord.
That is one of the matters, my lord.
There, my lord, his lordship had directed the parties to file their dues before the court, my lord.
Your Lordship, I represent one of the secured creditors, Your Lordship.
Copy this.
CP is assigned. So let it go. So CP is assigned before the Justice.
Main CP is assigned
So
before.
let it go before the.
Yes, my lord. That was my
Where is the order? Is there an order of assignment?
earlier, my lord.
But I do not have received any copy of this application.
No, my lord.
Your Lordship, I appear on behalf of this one of the secured creditors, Your Lordship. I also have not received the copy of the application, Your Lordship.
Okay, you file.
No, my lord, official. I
Counsel
have
for
served
the applicant.
on the official liquidator, my lord.
Counsel for the applicant submit that. The what is the CP number?
CP
The CP number 211.
BIFR.
BIFR number.
Of 1995.
No, 114 of
1995.
No,
1997. 114 of
114 of 1997.
Informed by the counsel for the applicant that BIFR case number 114 of 1997 has been assigned to another court. Accordingly, the CA 64 of 2025 filed in BIFR number 114 of 1997 is released from the list of this court with the liberty to the parties to mention before the appropriate court wherein the matter has been assigned. Wherein the BFIR number 114 of 1997 is assigned.
A similar prayer in next matter, 23 also, madam.
23 also.
23 also. My number is CA number 65 of 20.
Same, Kali BIFR number. The same, ma'am.
CA number 65, madam. CA number 65.
CA number 64 or 65. Okay. Released from this list, mentioned before the appropriate.
I'm
Yes.
good.
Deep